Right, good evening everybody. Welcome to the Planning Committee for 13th of November. Before we get on to the items on the agenda, I need to cover a few housekeeping matters, so if you'd just bear with me on that. There's a public address system which registered speakers can use. The table here in the front has a button on it. When that button is pressed, you are able to address the audience here, as I am currently so doing. There is no fire drill planned tonight. The proceedings are filmed and they will be available on the WBC website. The camera positions mean that it's the committee members, council officers and speakers who are recorded, but speakers may ask to be not recorded if they specifically wish, but they will be audio recorded. The Planning Committee consists of 11 elected members, borough councillors, and representing all four of the political parties making up the council. Political groups, should I say. We are supported and advised tonight by a variety of professional council officers. On my far right is Callum Wernham, who is the Democratic Services Officer and clerk to this committee meeting. And next to him is Mary Severin, who is the Borough Solicitor, who is here to give us any legal advice and guidance that we may require. On my immediate right is Councillor Chris Bowring, who's Vice Chairman of the committee. I'm Simon Weeks, I chair the committee. On my left is Marcia Head, who's the Service Manager for Planning, and next to her is Judy Kelly, who's the Highways Development Manager. And the various officers who will be presenting items on tonight's agenda are sat over to the left, and the people sitting on the rest of the left and right of the committee are the other committee members. The planning officers will present each item in turn, and the procedure is that because this is a quasi-judicial committee, we have formal and set procedures and conduct, and I would ask you to cooperate with me as the chair to ensure that they're adhered to. Firstly, the planning officer will present the application, then I will call in turn only those who have pre-registered to speak, and as I say, if you come forward to the table and use the microphone. The time allowed for each speaker is 3 minutes. Please be sure that you get your key points across in that 3 minutes, because we will cut the microphone off after 3 minutes. It's embarrassing for all if you go through your preamble and don't get to your key points until the 3 minutes is over. The other thing I need to mention, the members of the committee are interested, as always, in the quality of what you say, not necessarily the quantity. I must emphasise only that those who have pre-registered to speak may speak, and no others, including town or parish councillors, agents, applicants, objectors or supporters, are permitted to address the committee, interrupt proceedings or ask any questions. Following the planning officer's recommendations and presentation, the planning committee will then discuss, debate and question what they've heard, seek clarification if necessary, and hopefully reach a decision which may or may not agree with that of the planning officer's recommendation. Finally, our role is to determine valid planning applications using prevailing local and national planning policies. Our role as a committee is not to suggest alternative schemes, modifications to schemes, whether they're a good idea, whether they're needed, whether they're too costly, whether they're alternative uses. That is all within the remit of the applicant. So now, before we go on to tonight's agenda, there's just one other item I need to read out, and this is for members of the committee. Members, I need to remind you that we are in a pre-election period, and therefore, when speaking at this meeting, members and officers need to follow advice that has been provided to them by the monitoring officer. Okay, so if we could just go on to apologies. Who do we have apologies from?
Apologies submitted from Councillor Carl Duran, Chair.
Okay, thank you. And members have had sight of the minutes of the last meeting. Does anybody wish to make any modifications to those, or can I sign them as a true record? Yes. So are you indicating support? Yeah. Oh, right, that's fine. Thank you. Right. Okay. Thank you. And do any members need to declare declarations of interest on any of the items on the agenda tonight? Angus.
Just as a matter of explanation, Chairman, on item 51, although I'm a rambler and a member of the the representative on the Local Access Forum, I've taken no part in any preparation of this item and come to it with an open mind. And with item 53, as a lead member of the Fire Authority, who are the next door neighbour, again, I've taken no part in any consideration of their response.
Okay, thank you for that clarification. And Callum, are there any items to be deferred or withdrawn from the agenda?
Not that I'm aware of, Chair, no.
Okay, right. In that case, we'll move straight on to the first item, which is, I hope is an item that we can resolve very quickly. That is a diversion order on a footpath. And if you'd like to come up and present, Andrew.
There we are, thank you. This is an application for a diversion under section 257 of the Town and Country Planning Act to divert a path to enable pre-approved development to go ahead at Carnival Pool. And I believe we've got a map on the, is it here? There we are, thank you very much. This, there we are, okay. So we have a map here. It's essentially to divert the legal line of the footpath slightly to the northwest of the line. It will essentially terminate about 30 metres to the away from the original termination point, but will end up being a better path for the public. As I say, the grounds for making the diversion order is that part of the line of the path should be diverted to assist the redevelopment of the site under planning permission on the 2nd of February 2018 under reference 172012. The diverted route will be approximately 92 metres. It has a very small dogleg, but we recommend the order is made and that there will be no real substantive problems for the public.
Members, I would draw your attention to the consultation responses on page 10, where you see that the Ramblers Association, Open Spaces Society, Woking Town Council, British Horse Society and the Local Access Forum, none of them have raised any objections. And you'll see below that, nor have town or parish councils or any local members. So I'm hoping that we can process this without further discussion. Does any member wish to raise any items on this?
Only to comment, Chairman, that as a member of this committee that approved Southgate House some 20 years ago, I apologise that we didn't notice that the public right-of-way went through the site.
Okay, all right. Okay. Right. In that case, members, I'm seeing no one else indicating to speak or proposing an alternative outcome. Could you please indicate your support of the application as detailed on pages 9 to 12? And that is carried unanimously. Thank you, Andrew. If only all such applications were so short. It's okay. Right, okay. Thank you. Right, now, members, we move on to application 192128, which relates to Woodside caravan site in Wargrave Lane in Wokingham. And I will hand this straight over to the planning officer who's presenting this item, Graham Vaughan.
Thank you, Chairman. The application is to vary condition 1 of planning consent 181694 to alter the personal and temporary limitations relating to the provision of gypsy and traveller pitches on the site. The site is located off and accessed from Wargrave Lane. In policy terms, it is located in designated countryside, however, adjacent to the major development location of Wokingham, which stops along the edge of Wargrave Lane. The site comprises of an access track to 3 pitches. Grassed areas exist around the pitches, but there is a large expanse to the west, which is separated by a fence. From a wider perspective, there are 2-storey residential buildings to the east and north, as well as a public footpath and landscaped area. An electricity distribution site is located to the northwest. The site is accessed just opposite Blago Drive, and slightly further to the east is the access to the public footpath. And along the footpath, filtered views into the site are possible. Prior to this application, there have been a number of applications and appeals on the site. Previously, 2 applications to establish the use of the site for pitches were refused, and following occupation of the site without planning permission, an enforcement notice was issued. An appeal against this enforcement notice was lodged, but due to various reasons, the decision to dismiss the appeal was quashed twice. Following the 3rd redetermination, in 2018, an inspector allowed development on the site, but this was on the basis of a temporary and personal permission only. After this, another application was made to clarify the number of pitches and their occupants due to a mistake made by the appeal inspector. That application was considered and approved by the Planning Committee in November 2018. The current application seeks to vary Condition 1 of that decision, which in turn varied Conditions 1 and 2 of the appeal decision. Put simply, the application seeks to either achieve a permanent permission without any restriction on who can occupy the site, or achieve a permanent permission and amend who can occupy the site, or achieve a renewal of the temporary permission and amend who can occupy the site. In both the 2nd and 3rd instances, this would be to add 1 additional adult to the list of occupiers, and is as set out in paragraph 2 of the report. As the application seeks to extend the occupation of the site, it needs to be considered if there are any material changes since the decision made by the inspector to allow development. As set out in the report, the main issues primarily are the impact on the character of the area and the personal circumstances of the applicant. With regard to the character of the area, the inspector considered substantial harm arose due to the urbanisation of the site. With regard to the personal circumstances, the inspector considered the medical needs and education needs of the children who occupy the site. The inspector placed substantial weight on this aspect, as has been established through the courts in respect of the impact on human rights. For confirmation, the inspector based his decision in the knowledge that the council could demonstrate a 5-year supply of pitches, that landscaping would mature over time, and that there was little or no impact with regard to residential amenity, highways, ecology, or environmental health. As such, the decision was very much on balance, and ultimately the inspector considered the personal circumstances of the applicant outweighed the harm to the character of the area. Notably, however, this was only to the extent that a temporary and personal permission were acceptable. In determining this application, it is considered the same issues remain. There is clear harm to the character of the area, and landscaping would not overcome this. However, the personal circumstances of the applicant remain very similar, although there are additional children and 1 additional adult on the site. An additional factor in the planning balance is the provision of the local plan update. It is possible that this would result in an alternative site being found, which would allow for the site occupants to move. On this basis, it is considered that a further temporary and personal permission would be appropriate. As such, the recommendation is that the committee authorise the grant of planning permission, subject to amending Condition 1 of Planning Permission 181694, to allow a further 2 years of occupation on the site, but restricted to the persons as set out in the officer report.
Okay, thank you, Graham. We now come on to those people who are registered to speak, and we have 3 people registered to speak. So firstly, I'll call Philip Bain. Good evening. You press the button just in the centre. Would you like me to tell you when you have 30 seconds left, or are you confident you can get
No,
more?
I'm pretty confident I can keep to time.
Okay, thank you.
Okay, this is a statement on behalf of the residents of Wargrave Lane and the newly Bewley development that have fought the legality and justification of this site from the very beginning. We have submitted a presentation to the Democratic Service email yesterday with documents, pictures and videos supporting the below statement. We think more consideration and weighting should be given to the impact of noise and disturbance as a result of this site. We have raised this matter with council complaints, environmental health, police and even our local MP. However, find it concerning that these views are not represented fully within the planning report. Environmental health have been contacted on numerous occasions by various residents, and complaints have been upheld by the resulting in a visit to the site. We also believe the site to be close to residential properties and is impacting the health and well-being of residents living near and around the site. We believe there are inconsistencies in the planning report relating to alternative provision to pitches. We would like to have clarification whether pitches have been available and then found to be unsuitable, or have they not been available in the first place. We understand that the council is working towards the local plan of provision. However, this fact has also been mentioned in previous years, and we would like to understand what difference there will be this time. Are there conditions stated in relation to the word suitability that can be put into the council's decision, since there seems quite arbitrary and lends itself to further opportunities of further sites being turned down without valid grounds? The conditions of the use of the land within the report state that there should not be used for commercial purposes. We reported to the council that there were various trade vehicles entering and leaving the site and businesses registered there. We would like this to be taken into account when a decision is made. Finally, whilst not a grounds of planning matter, please note that one of the people named in the planning application is wanted by police on a recall to prison. We have been advised by the police to only call them if we can guarantee that this person is present on site, otherwise they are likely to flee. Is it the council's position to defend the rights of occupants that are convicted of criminal offences over the rights of tax-paying, law-abiding residents in the area, since this seems an injustice to us? The report is heavily weighted towards the impact on council provision of sites. If this application were to be approved, however, the residents and we feel the council is not representing the interest of the local community and considering the impact this is having on our daily lives and our families' daily lives. Not to mention the ongoing development is causing harm and character and environment to the land and surrounding area.
Okay, thank you very much. I'd now call Letty Morn, applicant. Hello. If you just take a seat and you'll see the button at the bottom of the microphone. Just if you press that, you'll be able to hear you. Off you go.
Right. All I basically want to
Keep the button pressed. Can you keep the button pressed down to the lights on? That's it. Just leave it now.
after most of what's just been said is just a load of nonsense. There is no criminal activity. In regards of going back to our previous meetings, he just referred to it as there being subsequent noise and all this, basically a lot of drama going on. In our previous meeting, he said that we was lying because we didn't have all these kids because he didn't hear them and he never seen anyone and we wasn't occupying the site. So I think there's a bit of a, today we were a nuisance, last meeting we didn't exist. So I think there's a lot going on. In regards of the police, you can probably check it yourself anyway. You'll see we've never had no problems with that. There's people obviously in this room with regards of the vehicles being parked there for trade. Graham he's been down there. We don't have anything over 3.5 tonnes. That's what's clearly stated we're not allowed. They're only normal transit vans. One transit van that's just for their normal trade. Apart from that, everything that we're saying in our application that he has is the truth. We're not lying about anything about kids. As you can clearly see, there's one that's just been born there. Like they said that he didn't exist either, along with the other 18 kids that's on site. So there's a lot of, obviously I understand we're gypsies and travellers. There's a lot of racist stigma. It's, as Mr. Baines has previously said to me, it's devaluing his property. That's why I don't want it. But I don't think that's a good reason to make 18 kids homeless just because someone is upset about the value of the property. I understand, ideally, not everyone accepts us, but if not there, then next to you, we've got to go somewhere. There is clearly nowhere else to put us. We've looked, we've hunted, we've even rung Jason and said if we could do land swaps would we be approved? Because he said if that was the case, then they'd overlook it. I spoke to Marcia herself before, and she did say, well, if you find anything, give me a call, and I'll let you know if it's appropriate. We've done everything we can, and we're still hitting up against a brick wall. Obviously, we've got kids with disabilities. One of the people that they was referring to on there, the adults, has got disabilities. We've had a lot of ongoing family problems of deaths and people passing away. There's 5 kids on that site that don't have a dad. He passed away back 4 years ago. They got left from being the age of 2 and 8 with no father. But there's a lot of people that hasn't asked us, where did we come from? What's the circumstances behind? Why are we there? What they're saying, why did we leave where we previously lived? Well, half of them kids left because they seen their dad die on their doorstep. That was the reason why they had to leave. Obviously, it was mentally disturbing for them.
Okay.
So.
Okay, thank you. Finally, Sarah Kerr, ward member.
Thank you, Chair. As local councillor for Evandon's ward, I cannot support permanent permission being granted to Woodside caravan site, and I'm equally frustrated that temporary permission is being advised. This is land that was not identified as being suitable for occupation. It is outside of the local plan and is land that forms part of a buffer zone between developments and has resulted in a loss of green space that negatively impacts on residents, wildlife and the environment. The planning inspector at the last appeal even stated that there would be substantial harm to the character and appearance of the surrounding area if permanent planning permission were granted. I then ask, if it would cause substantial harm for permanent planning permission, then surely it's the same for even a temporary one. The longer this site remains an urban site, the more harm it does to what should be countryside. I refute the comments about natural screening having gone up. There has been some, but when I stand on the edge of the Folly Court development where many of my residents live, the screening does not go far enough. Just some pictures to show you. It certainly doesn't look like the countryside it should be. You cannot change the fact that what was countryside has become urban. The only reason why temporary permission was granted was due to the human rights issues. And as I've just stated, even the inspector agreed that the site's not suitable. So I'm questioning why in the 2 years since that decision was made, are we not in a position now when we're able to refuse even temporary permission on the site? There's been time to find suitable alternative provision that doesn't negatively impact on the human rights of the occupants, but have failed to do so. The council has enough supply of gypsy and traveller sites as stated in the report, more than 6 years' worth of supply. The occupants have chosen not to move to one of those sites, though, because of the other families that inhabit those sites. I'm frustrated by this because I and my residents do not get to choose who our neighbours are, so why is this any different? And how do we know what effort has been put into finding alternative sites by the occupants? What is incentivising them? Due to the human rights aspect of the decision, residents of the site must be named. Mistakes, as we've heard, were made on the previous appeal. The application originally was for 2 families, it then got put to 3 families, and in this particular case, we're seeing an additional person being added to that list as well. The fear is that not only will this site become permanent, but it will continue to grow and grow. Whilst we're here tonight looking at this specific application, perhaps some thought could be taken as to how much gypsy and traveller site provision on non-private land is in the public local plan update. Because how many times can we keep granting temporary residency before it's effectively permanent? Taking everything into account, I cannot support permanent or temporary permission being granted to Woodside caravan sites.
Thank you very much. I think I'd just like to clarify a couple of points before we throw this open to members to question and get more information. A number of statements have been made about the applicants and the residents nearby. I'd just like to get absolute clarity on that when we consider planning applications, we consider them on their planning merit. We do not take into consideration the suitability of the applicant, whether they have past history and what that history may be. That is something we do not consider in planning terms. So I just wanted to make that very clear. And the other thing is, as all the members of the committee know, comments were made allegedly about land value or house values. Again, that is not a matter for the planning committee to consider. The planning committee, I would urge you to concentrate on the planning aspects of this application only. Right, we now come on to speakers. I think, Stephen, you're the first person indicating to speak. I've seen it.
Thank you very much, Chairman. And I'd just begin, if I may, by amplifying what you've just said. I think it's very important we consider this application in a dispassionate way and purely on planning terms. What I would like to, moving on to my comments about it in planning terms, I note that the decision at appeal was an on-balance decision, and this recommendation is also an on-balance decision. And that, I think, is an important point to make. This is clearly, there are arguments on both sides. What I think is indisputable is that the application, in its various forms, before, when it's gone to appeal, and now before us, is in conflict with our own planning policies. It's in conflict with policy CP11 of the core strategy, which relates to proposals outside development limits, and it's in conflict with policies CP1 and 3 of the core strategy relating to character of area. I don't think anyone disputes that. And that I think is accepted by all parties. It certainly was accepted by the appeal inspector and is accepted in the officer's report. The question really is whether there are weighty enough considerations to put aside or at least eclipse these important planning policy reasons for refusing the application. Now, clearly there are personal circumstances that were, in the view of the inspector, significant, and therefore, on balance, he decided the significance of those personal circumstances merited granting a temporary permission. Now, the applicant would have preferred a permanent permission. Clearly, the applicant would like to stay on the site permanently. That, I think, clearly was not what the appeal inspector thought was acceptable. We're now being asked for a further temporary permission. Now, the real question I think we have to ask ourselves is whether we can grant a further temporary planning permission. The circumstances of the applicants have changed a little, that's clear. However, in essence, those circumstances were taken into account fully in granting temporary planning permission the first time round. We're being asked to take them into account again to grant a second extension, which seems to me difficult to accept, especially I have to say, because on page 24 of the report, when this critical issue of alternative sites, which the applicant explained that other sites were not thought to be suitable from the applicant's perspective. But the report tells us that we've really had limited evidence to demonstrate consideration of other sites, although an acknowledgement, obviously, that attempts are being made. I really do think if we were to be minded to repeat temporary permission, we really do need a lot more assurance about what efforts have been made to see whether there are alternative sites that could be suitable. And I don't feel we've got that assurance at this stage. So my inclination at this point is to say that we should not be granting further temporary permission. We should be accepting that the limit is up on the time.
Okay, we'll just carry on. Just carry on moving round.
Thank you, Chair. Whilst I empathise with those currently living on the site, I do have a number of concerns. Taking into account traveller site policy and personal circumstances, the planning inspector clearly believed that the soon-to-lapse 2-year permission to occupy the site should have been adequate. The same concerns outlined in all of the documents relating to this case persist, including those in the planning inspector's decision. However, the Borough Planning Officer's recommendation for a further 2-year extension may or may not be supported should this be returned to the Planning Inspectorate. Continued, albeit further time-limited occupation of the site would not be what was originally intended and would not be considered to be the most desirable outcome for many stakeholders. Notwithstanding, we are where we are, and the same reasons that led to the previous decision persist. For this reason, at this point, I might possibly support the application for a temporary extension. However, I would like to ask for 3 points of clarification. I am concerned at the use of the phrase, an alternative site could possibly be found a number of times in the report, and that a suitable site was not found during the current 2-year extension. Is it truly realistic that a suitable alternative site can be found should an extension of 2 years or of any period be granted? What would be the most likely outcomes should this not happen? Secondly, in this instance, the number and names of adults allowed permission to live on the site is specified. I believe I understand the reasoning behind this, though I'm not entirely comfortable with this. Still, what monitoring occurs to ensure compliance, and what powers would WBC have in the event of any breaches? Thirdly, sight lines are said to be achievable from the access. I note that the site is opposite a T-junction. Presumably, some of the vehicles entering and leaving the site are quite large and cumbersome. What's the current speed limit along this section of Wargrave Lane? Can we have assurances from Highways that they do not believe any works are needed to improve safety at this location? And if those assurances are qualified in any way, that this be addressed? Thank you.
Right. We'll carry on and we'll try and summarise these and we get towards the end. Angus, did you wish to speak?
I would later, when I've heard an answer to points that Andrew has brought up.
Pauline?
Thank you, Chairman. I think the key point for me is page 45 on the appeal letter, where it says, when the premises cease to be occupied by those named above, or at the end of 2 years, whichever shall first occur. Now, my understanding of that is the inspector saying you've got to actually make an effort to find an alternative site. And if we continue to extend this because it's not occurred, we're actually not doing what the inspector said in his letter. We're actually not following the letter, which clearly says you've got 2 years to find somewhere else, or you're out, you have to move on, or if you find somewhere else earlier, you also have to clear the site. So the recommendation of the officers doesn't actually align with the inspector's letter, which I find a bit strange. So I wonder if the officers could explain that one. The second one was on page 24, which says that the 6.25 years worth of pitch supply. Are there any actual vacant pitches? Because I've got a lot of sympathy for people who can't find a pitch. So is there actually vacant pitches that equate to that 6.25 years supply, or is this just a future potential sites as opposed to actual sites that they could move to?
That's actually quite a key issue. So we've got somebody from the policy team who will hopefully give us some clarification on that once we've been round the rest of the members.
Thank you, Chairman. I think Pauline has echoes what I wanted to say. But beside that, what has been done since last 2 years? Have they done anything that we can look into it, or? Because once it's granted 2 years, we seem to be, granting, if we were to grant another 2 years, it's like an ongoing thing. So I'm a bit confused about extension.
The position on that is if somebody has permission to do something that is time limited, that is the time limit. They need to then apply if they want to extend that time. And that's what we're discussing tonight. Okay. Rochelle?
We keep talking about alternative pitches and alternative locations. Will something be in the local plan update to include some alternative pitches? Part of the problems are the different families don't necessarily get along with each other, and I can see a lot of places where I know lots of people in previous families that I've been involved with. I wouldn't want to live next door to some of them. So that's about all I can say. Where will we be able to find some new places that they could go to, and when? That's the question. Yes.
A couple of questions, mainly. It's when do these permissions start from? Because the permission they got was in November 2018, and that hasn't expired yet, has it? That's when we gave them the permission. How long is that? When does that expire? And would any extension that we gave actually start after
The permission expires in January 2020, so in just over 2 months' time.
Okay, just that November 2018 plus 2 years isn't necessarily January. However, any new date would begin then for 2 years or whatever it is, from January 2020 onwards, regardless, without any changes as identified in the rules. Okay, could we be reasonably sure that in 18 months to 24 months we don't have a similar situation, because we seem to be getting a repeat performance of the application that we can't find anywhere else, and there's another adult and another child? Can we have a condition that says that?
The bottom line is we cannot condition something that somebody may wish to apply for in the future. So I think what you're saying is, if we were to grant this 2-year permission, could members of the committee be asked to do the same again in 2 years' time? And the answer is yes, they could. So we cannot preclude somebody making an application in the future. Mary, would you confirm that from a legal position? Thank you. All right.
I don't think we can refuse this this application outright. I think we have to consider the position now in light of the inspector's report. And the fact is, the difference between now and 2 years ago is that, for example, the children are more embedded in the local community. So I think it must therefore follows that the inspector would make a similar ruling now. I don't know what Stephen was thinking of deferring for more information, but I would like to suggest we do that to get some clarification on exactly what efforts we have made or would make if we grant another extension. And if we do grant another extension, I think if a suitable site were found, then the permission would expire 3 months after that period, so it doesn't necessarily have to run for the whole 2 years.
Well, I would point out to the committee that it's my understanding that even though the applicant is asking for a 2-year extension, the options within the remit of this committee is to deny that or to provide a shorter extension period if they so chose. Okay. Gary.
Thank you, Simon. We were all sent a letter by a local resident. I see from the email address that was copied to every one of us. And he makes some points which I thought were helpful, perhaps. Or he said, some months ago in an email, you tasked me to find alternative accommodation for the travellers in the borough, as your crack team of planning specialists have been able to find suitable alternative accommodation. And he makes a reference to Pine Ridge Farm. He submitted pictures where showed 2 sites, 2 areas that sorry? Oh, my apologies. That could take 6 and 12 pictures. It doesn't solve the problem. It doesn't solve the problem we've got at the moment. I think the inspector's made fairly strict points that need consideration. But having said that, one of the biggest problems we've got is the local plan update, which should have been dealt with at the beginning of this year, is now delayed for public inquiry, I think, to the beginning of next year. So that'll be 2020. It'll be towards the end of 2020 before we get a result. In that local plan, there will be a need to look at traveller pitches and find locations for the appropriate number that's needed. So in a way, the timing of this is not very good. I do concern myself with 19 children living on such a small site, although that's not an issue for this planning committee. My personal view is, subject to suggestions from other people, is that the officer recommendation would be acceptable, but I would insist on it not being a condition that it's extended by 2 years, but it's subject to a legal agreement. And I would also suggest that the letter that I received from this resident shows a very clear issue with light pollution on the side of one side of the site. And I think that we should put a condition, if we decide to go ahead with it, that we put a condition on there being screening to protect the light pollution from the residents in the surrounding area. And I may have more comments later.
I think before we go any further, I'd like to get some clarity on some of the points. Graham, could you attempt to address the various points that have been raised by the committee?
So I have to echo some of the things that have been said, in that we are determining an application on its own merits. That application is to essentially extend the occupation of the site. The issues that are raised are very much the same as what they were in 2018 when the inspector considered them. Ultimately, they haven't really changed. So it is the view of officers of the council that we are applying the same weight to those issues, therefore we come to the same conclusion. It's also the view of officers that if the application were to be refused and go to appeal, it's very likely that an inspector would also consider the same things and apply the same weight. So that is something to very much be aware of.
Stop you there. The inspector in assessing this played considerable weight on the needs of the children on site. How would you feel the inspector would view something in view of the fact that there are now additional people on site? We're talking about an additional adult and several other children. Would you see the inspector as seeing that the need is unchanged or increased?
Ultimately unchanged. I would say that regardless of the number of children or indeed adults, that the weight that you apply to that part of the argument is still the same, and the needs of the children have been held in very high regard in the courts. One of the issues raised was whether or not we would be able to monitor the site. Ultimately, that's part of the enforcement aspects of planning. It is something that we do actually work quite closely with residents of the site, so we are generally in contact, but ultimately it is down to the enforcement aspect. But that is a separate part of what we're considering tonight. Did you want to touch on highways? Yeah, I might defer to Judy on that.
Specific questions about visibility and the speed limit.
The speed limit for the access, it's within a 30-mile-an-hour speed limit, so the 30-mile-an-hour starts about 160 metres to the south. So in terms of visibility displays, the requirement would be in line with manual for streets, which is a 2.4-metre setback and a 43-metre distance along the road in each direction that would need to be kept clear. It would have been part of the original appeal decision to grant approval to the site. If there's any significant highway safety issue with the access, then there might have been a different outcome.
If I can add in regards to temporary permission, which I think partly what you're getting at, it is possible in planning legislation to allow a temporary permission and then to submit further applications, and there isn't anything to say that you can't keep doing that. Obviously it's not what we typically do, but it is possible. So the point being that we are coming to the same conclusion as the inspector.
But that's not the case. The inspector said you got 2 years extension and then you vacate the site, or if you find something earlier, you vacate the site. If the inspector was expecting continual 2-year extensions, he wouldn't have said you have 2 years and then regardless of whether you found anywhere or not, you vacate
the issue. The issue at hand is the inspector was passing judgment on the council's previous decision. The inspector, that if you like, was his decision. He cannot, because even though he's made a decision, he cannot prevent, as I said earlier, the applicant putting in further applications, which would then be considered. If they were refused by this council, the applicant will be perfectly at liberty to go to appeal and have the appeal inspector look at it a subsequent occasion.
I think the point I was trying to make was, if the inspector wanted us to or expected us to continue extending this if there was a further application, he wouldn't have put the condition that said after 2 years you have to vacate the site regardless of whether you found an alternative accommodation or not, I would have proposed.
Personally, I see that that condition or clause in a lot of appeal decisions where it's temporary. He's basically saying, yes, I will give you something temporarily, but should, for instance, if it's for an urgent industrial use on a site, he might say you're getting 2 years permission, but if that use falls away after 18 months, I expect you to be gone from the site in 18 months. That's all they're really saying. That is absolutely correct, but that is why the applicant is now making this planning application. Because that is an event that the inspector has passed judgment on. They're now trying to get a change of that done by the council. Okay. Yes, Graham.
If I could just add, the inspector also, I think, considered that the local plan update would have been further in its progress than it currently is. So that was another reason for giving 2 years temporary.
Thank you very much. And can I thank the officer for the clarity of the responses? They've been very helpful. And also for his report, which has been very balanced and I think, again, helpful. I remain very uncomfortable about this application. I am comfortable because, as is very apparent from everything that's been said in the last few minutes, the applicant could submit repeated applications for 2-year extensions. And if the circumstances have not changed, presumably the recommendation will be to continue to approve. The applicant actually would have preferred a permanent permission. They won't be granted a permanent permission, but they will effectively, over time, get a permanent permission by repeated temporary permissions, which the council, it seems, feels we're not in the position to refuse.
If I don't mind, I would just like to clarify there that clearly we can't prejudge that if a future application came forward, what the committee's decision would be on that. And clearly we are all human, believe it or not, and if the committee felt that the applicant was really not making the necessary efforts to find another site, this committee's willingness to agree to a further extension may well be curtailed.
Is the very point I was coming on to, that I understand why you wanted to intervene. The very point I wanted to come on to is that the way we could actually avoid this difficulty is actually getting more information on what efforts have been made up to now in this existing 2-year extension period to find an alternative site and why alternative sites have not been judged to be suitable. I think we need that information before we can make any judgment on the current application. So I'm very happy to support the Vice Chairman's suggestion that we defer this item to get that information before any decision is made. I think that's the fairest way forward for all parties concerned.
Okay. Notwithstanding that, I would like to just hear from the policy team in terms of, I think all members would benefit from understanding the position. James, I wonder whether you could just briefly swap places with Graham and just give us some clarification on the Gypsy and Traveller land supply position and currently and the outlook.
Yeah, thank you, Chair. There are a few people correctly identified that the Council can demonstrate a 6.25-year supply of Gypsy and Traveller pitches. I think there was a question in there of whether those pitches are available now. Essentially, the situation is the land supply is calculated on an annual basis, based at the 31st of March. At that time, the position is based on deliverable permissions which will be delivered over the subsequent 5 years. So the period we're in at the moment is 2020 to 23-24. So that 6.25 years is made up of extant planning permissions. Some of those will have been implemented in the subsequent 8 months, but it's my understanding that they've been implemented, are currently occupied. The remaining permissions essentially haven't been delivered yet, so aren't available now. It's a future supply position. So while we have got the necessary land supply, it's still a material consideration of whether there are available pitches that are suitable and available at this point in time. I would say that we have, since that position, approved additional pitches. So there's 3 additional pitches have been approved on a council site, and additional 5 pitches on Belvedere Park, which at some point in the future, when they're delivered, will become available and potentially available to the applicant. But clearly our own council sites, we've got a waiting list and due process and how that's allocated.
Get clarification on one point, that is in terms of trying to identify sites suitable for gypsy and traveller sites. Would you expect this site that we're considering today would be one of the sites that might be considered?
Yeah, so through the local plan process, we'll be consulting on a draft plan kind of early next year. We have had through that process a number of private sites which have been promoted to us for gypsy and traveller use, which are all being considered at the moment. In addition to those sites which have formally been promoted through this Call for Sites exercise, clearly we need to have a look at the sites that are existing in the borough, and this is a site where it's there are occupiers, and through that local plan process we will be assessing the suitability of the site. And it's within the gift of that local plan to allocate additional pitches.
Thank you, Chairman. Just to follow on from that, how long does it normally take from the granting of planning permission to actually have a site that's available for somebody to actually live in?
Very often there's quite onerous planning conditions that need to be discharged. So, for example, if there was a contaminated land condition, it could take a year to discharge that condition. So it can easily take a year, if not longer, to deliver pitches.
To ensure a balanced view, I would also point out that some of the sites that are granted planning permission are actually being granted it retrospectively. So they're actually immediately available, it's just that previously they haven't counted. Fair comment? Okay. Angus, you wanted to defer speaking. I'll now come to you first.
Yes, I think that policy statement there was very useful. I mean, we're all clear that the site is not within our planning policies, and at some point we will trust that that will be regularised. But the alternative sites today is the issue. And the evidence we've just heard is that they're not there today. In fact, the only way, perhaps, that this applicant may find a way forward is to find their own site over a period, now or later, and get their own permission. But that's not for us to discuss today. But I think, on balance, we, because of all that situation, as of today, should support this application, both in the absence of progress on the local plan update, which we've said earlier the inspector would have thought would have been further ahead, and other people as well, and further sites becoming available. Just one comment. Earlier, we were shown the picture about the light pollution, and I'm not denying there isn't any, but I today have just measured up between the houses in the guide dogs development and it's almost 130 metres away from the nearest house. So yes, there may be light pollution. I wouldn't have thought it's that great.
I don't think we can define what is a suitable site for these people. They decide what a suitable site is. We'd be more of a totalitarian government if we said, oh, this site is fine, you have to move here. We can't do that, I don't believe. And should we decide to turn this down, most likely the appeals would overturn us. It would cost us costs and things like this. So how do we define suitability? That's what I'm trying to find out. We don't seem to have a definition of this, and
tonight, Rochelle, we're not looking to, whilst the applicant may well be seeking an appropriate site tonight, we're just talking about this site and whether they will be granted a 2-year extension or a different period. And I think we have a proposal being put forward on that in a moment. Andrew?
My question was about the availability of sites, and that's now been answered by the policy team. Thank you.
Stephen and Chris, you were both talking about a deferral. Would you like to elaborate, please?
Yes, I would still like to suggest a deferral, because although from the policy evidence we've heard, it doesn't appear that there are sites available at the moment. That seems not quite to square with the last sentence of paragraph 9 on page 24. Whilst it is considered limited evidence has been submitted to demonstrate consideration of other sites, it is acknowledged that the applicant has made an attempt to find alternative location. So I'm a bit confused. If there were no sites to be found, how could you have made those efforts? So I'm assuming there have been some sites that have been considered, and I just would like to know what the evidence is of how they've been considered and why they've been rejected. So I would still suggest that we should defer this application to get that information before we make a decision.
Another question. No, I've got a question on Stephen's. Aspect of his proposal. I'm interested in the timescale because if the planning permission on this site runs out in January, are we knocking it past the end point of that permission?
I would wish it to come back. Sorry. Well, if it comes back in the January committee, and obviously this council isn't going to take enforcement action against the applicant for going beyond the original existing 2-year permission, because we've actually prevented a decision being made by asking for a deferral. So I'm mindful of that. I think January would be the latest we'd want to do it.
There can't be an enforcement action if there's this planning application. Oh, okay.
Because it's not determined.
Yeah.
Okay, so members, we've had a proposal to defer this and to bring it back no later than the January Planning Committee. And in that time, it will be a requirement for the applicants to provide some evidence as to what you've been doing in order to find additional sites. And then we will make a decision on this in January when we have that additional information. Members, do you wish to support that deferral? Please indicate. 2, 3, 4. Right. So that item is deferred until January next year, which is going to come around remarkably quickly. Graham, could I ask you to ensure that you liaise with the applicant so they have a full understanding of what kind of things we're looking for on this? Yep.
Yes. Could I possibly get a bit of clarification from councillors?
Yep.
Exactly what it is that you want to see.
So I think, sorry, could we just have a one meeting, please, Malcolm? Thank you. What evidence is it you would like to see? Because you've said you'd like more evidence, and it's not unreasonable that we provide some clarity on that. So what evidence, Stephen?
I would like to know what sites were considered and why they were thought to be unsuitable.
And dates.
And presumably whether the applicants have identified any sites themselves and had any pre-app discussions with planning officers about them. Yep. because that will change over the next couple of months. So the position could be worse or better in January when we consider this again in terms of availability. Right, I'm going to move on now. Thank you very much. So that's the position on that one. We now move on to the next planning application, which I'll get to in a moment. Right, this planning application, okay, we'll just get everybody in. This planning application relates to the site that some of the longer term residents may recognise as the old Ritz Cinema, I think, no less. That's how I remember it. We'll go straight over to you, Simon.
Application 19-1573 involves the demolition of the existing cinema building at 9 East Hempstead Road and the construction of a part 3, part 4 story flat building with 22 units across 4 stories and parking on the basement level for 23 car parking spaces. There's a mix of units from studios to 3-bedroom units. And there's 2 units at the front of the building and 2 units at the rear of the building at ground level. The application follows a previous refusal in 2018 that is currently under appeal. The application is yet to be considered by the Planning Inspectorate, but the decision should be imminent. The applicant has indicated that if a decision is made for approval this evening, that they will withdraw that appeal. The site has an extensive planning history. It has resulted in the cinema building being converted or part converted over the past several decades to include retail, offices, gymnasium, residential and a bingo hall that is no longer used. The primary concerns raised have been from the Woking Town Council, a listing from the local ward member and 7 objections, mostly from the rear of the building. The primary concerns raised are the character, density and the height of the development in the streetscape. The existing building here is shown in the photographs as viewed from the street and from the rear. From the street, the building does extend to a total height of 10.3 metres, that's as opposed to 10.8 metres. It's also set back further in the plot. It is also set further forward in the plot than it is existing. The overall height measured to the 4th story will be 12.2 metres, so there is an increase in height of the building from the street. But the interpretation of it from the street is that it is set back behind the front building line, depicted in this photograph here, so it is less visible from the street. From the rear, similarly, it's 8.5 metres in height versus 8 to 12.3 metres. So there is a reduction in the rear, the height of the building at the rear. The relationship being important to the residential properties opposite view on the plan here. Most of the residential properties in Denton Road, these are the properties in Denton Road. There are also residential properties on East Hempstead Road. So in summary, in relation to the character and the density and the height of the development, there's suitably positioned in the site. The 4th floor is screened and there's an appropriate building line. A second issue raised by residents and the Town Council and the board member is the lack of parking, access arrangements in Denton Road and traffic impacts. The application is non-compliant with policy. The parking spaces are allocated spaces for each unit. There is 1 space per unit. This was found to be acceptable because of its town centre location and the supplementary, the SPD for the town centre does envisage lower parking rates for the area based on its high accessibility and access to services. Neighbour amenity concerns are acceptable. The scale of the building to the front and the rear and the relationship of windows is acceptable. To the side, you've got a fire station on one side, which is depicted here, and onto the other side you have a office building. Internal amenity was raised as a concern. The units are now compliant with all but one unit. Another concern raised was the energy efficiency of the building and the climate emergency. Additional measures should have been implemented in the scheme. Council's policies don't really allow that to, currently allow that to be implemented in this scheme, but the proposal was acceptable from building sustainability standards. Affordable housing is fully compliant in a form of on-site provision and commuted sum. It is otherwise an acceptable outcome for the town centre location, sympathetic design. Specific conditions relate to condition 3, which requires the interior of the building to be properly assessed in terms of any impact, any existing features of the cinema building that could be retained in the future development of the site. Condition 6 requires an extensive demolition and construction management plan, noting the location of the site in, close to schools and on East Hempstead Road and the residents to the rear. Condition 12 requires additional archaeological details, and Condition 1 limits to deliveries to outside of peak hours and schools. Just the members' update does make some some comments on additional highway issues, and it does update the affordable housing rate. The recommendation is for approval subject to those conditions and legal agreements relating to Thames Basin Heath mitigation, affordable housing and an employment skills plan. Thank you, Chair.
Thank you, Simon. Before we come on to the speakers, just members, I would draw your attention to the members' update, particularly the contents of paragraphs 3 and 4 relating to parking. It's important that you take note of those. In fact, we don't have anybody registered to speak for this item. So we can go straight across to members. Do we have ward member here? No, there isn't. So we'll take first person indicating.
Thank you, Chair. May I comment on and seek clarification on 2 matters? First, my main concern is with parking. I support the Wokingham Town Centre Master Plan's commitment to, quote, materially reduce parking, car parking provision. I also appreciate the observation that 35% of occupants within flats do not own a car. However, I am concerned that the proposed 23 spaces may be inadequate. And reasons for this include 5 of the spaces will be for electric charge, will have electric charging points. Does this effectively take them out of general use? I don't know. General use by residents. I believe 3 spaces for disabled users and 1 for visitors. The planning officer's presentation stated that there would be 1 allocated parking space per unit. I couldn't see any reference in the documents, although it may well be there, about whether the parking spaces would be allocated or unallocated. But this doesn't seem to tally with the figures that I was quoting just a moment ago. And the reasons why I'm worried about this is that I'm concerned that at times some residents and visitors are likely to find it difficult to park on site, and that parking would then spill out onto the streets that already have parking restrictions. I am concerned at the impact that this would have on residents in the proposed building, in the proposed dwellings, and in the neighbouring properties. And I don't have any thoughts as to how that might be mitigated. The second comment that I'd like to make is very brief, and I hope it's a positive comment. It's about energy sources. I note the decentralised energy details. I also note and approve the inclusion of photovoltaics tiles to be used on the roofs. Although it's not clear from the plans how extensive these would be. I wonder whether if there's any scope for the committee to make a recommendation that these be used as far as practical. Thank you.
Okay, I think on this one we'll address the points as we go along. So, Simon, perhaps you could just confirm, my understanding is these are allocated spaces? They're all allocated spaces?
Correct, paragraph 114.
Yep. Okay, the position on charging points, I think Andrew's question was, are they only available to people with electric vehicles, or if, for instance, all future occupants none of them had an electric vehicle. Presumably the spaces will be managed by whoever the agency is that is managing these properties. It's not a matter for the council, is it?
Oh, correct, insofar as condition 8 does require a car parking management plan which would address that issue.
Okay, so, and again, that presumably applies to the disabled spaces if there were no occupants, since they're allocated spaces, who needed a disabled space, those spaces could also be made available to the other residents in the site.
Correct. I would envisage that the management plan would allow some swapping of spaces to be flexible.
I think we've seen that on other sites, haven't we, when there's a parking plan to accommodate flexibility. And then Andrew also mentioned the impact on neighbours. I think your report does identify there being no particular concerns about overlooking. Was there any aspect of that you think is marginal? Or?
It complies front to front on East Hampstead Road, and it complies rear to side and rear to rear at the rear of the building with council's guidelines.
Okay, that fully complies for the increased distances required for 3 stories and above?
Correct, yes. So at the roof lights and the
required
top levels.
Spacing as soon as you go above the 3 stories and above is greater, so it's compliant with those.
There is a degree of overlooking to the sides of the property in terms of relationship with the fire station. My understanding is there's dormitory space on the top level of the
traditional
fire station,
is it? No.
And there's office development opposite on the other side, on the eastern side. There's a degree of mutual overlooking. It's residential, non-residential, considered to be acceptable in town centre location.
Okay. And Andrew's last point related to PV on the roof. We presumably, do we have the powers to require a certain amount of that, or is this all determined under building regs?
Condition 13 requires a minimum 10%, which is in accordance with the policy. They are entitled to achieve a higher percentage than that, or that is often the case with most developments these days. This is 2014 policy. How they achieve that is entirely up to them.
Okay, so whilst they may have a requirement to achieve 10%, presumably we could, if we wish to add an informative, encouraging the applicant to go for something greater than 10%? It is only an informative after all.
That'd be welcome, yes, 100%.
That be acceptable? Yes. Okay, fine, all right. Who else wishes to speak on this? Rochelle?
Parking, of course. Sorry. I think the problem is going to be the same that on most of the buildings, which everybody claims 0.91%. 0.91 spaces per dwelling doesn't really work very well. The flats on Rose Street were built without parking, as they said they'd never needed because it was right in the center of town. At this point, according to some of the local residents, there are 2 cars per flat in the buildings there. And where are the cars going to go? I do agree that we do have to redo the Borough Design Guide and change that.
Yep.
But in the meantime, I'm just not sure that it's adequate parking for that area.
Okay.
Unless you can tell people they can't have cars. They've done that. They've tried to do that in a few places in London. It hasn't really worked in most places. I don't think we're going to require people to not own more than 0.9 cars per.
Okay. Well, I think the report is quite clear that this is not parking policy compliant, but that's why I drew your attention to the 3rd paragraph of the members' update, where there have been a number of other town centre sites where, if you like, a precedent has been set by allowing less parking spaces than the number of units. Here we've got the same number of parking spaces as units. So in essence, Simon, this is actually, you're applying a slightly higher standard here than were applied at West Forest Gate and Saxon Court. Is that right?
That's correct.
Okay. Malcolm?
Very quick question. The allocated, parking spaces, are they allocated or unallocated?
We covered that earlier.
I didn't hear the answer.
Allocated. Pauline?
A question about landscaping, actually. I was a bit disappointed with the absence of landscaping at the ground level. I know what currently there is hasn't got any landscaping and is a... But this is residential, so it's slightly different. I would have hoped people would like to live in a more sort of green area. So I was a bit disappointed with that. I don't know whether there's anything we can do to try and improve that. The other question I had was about the first floor deck, which has got a lawn on it. And again, I'm not sure how usable or practical that is for children and families and that sort of stuff. One floor up. I can imagine people playing football on that and it not going down terribly well. So I'm just, what I'd like to understand is whether we can insist on better landscaping, whether there's any conditions on that. And the other very quick question was about the delivery hours for materials on site. I note it's earlier on Saturdays than it is during the week. Is that because of school transport?
Yes, it is. It's specifically to avoid adding to the inevitable congestion with a school fairly close by. Okay. Simon, could you just clarify whether there's any scope to bolster the currently non-existent screening?
East Hampstead Road's a green route, a nominated green route. Paragraph 146 acknowledges that, and the trees officer has requested additional landscaping to East Hampstead Road. The setback of the building does allow for some landscaping. The plan's on the screen at the moment, to the front there and to the rear. Condition 4 also requires a green wall to an otherwise blank facade over on the eastern side facing the office building. Those details should be provided in the landscaping scheme. In relation to the roof terraces, the concern in the previous planning application that was refused was that the three-storey building at the rear did shadow the development, the landscape deck for most of the day. The height of the building has been reduced to the extent now that it is receiving more sunlight than it would have otherwise in the previous scheme. Condition always also requires soil depth, trees that are suitable in shallow soil depth to maximise the potential of that landscape deck. Obviously, it's not a standard garden. It is elevated and it has a concrete base, so it is. The condition is intended to maximise the potential of that site. Okay, and did you just reaffirm the issue about the previously refused scheme? That, my understanding is that is at appeal, and the applicant has indicated they will withdraw that appeal if this scheme for a lower number of units is approved. Is that correct? About 2 weeks ago, he did advise that. The position hasn't changed since then. No. Okay, fine. All right, Gary.
We're getting back to car parking again. With allocated car parking spaces, should we not look at there being electrical supply to the whole parking area to enable electric vehicle charging in wherever it may want to go? Because the problem you've got is if you've got 5 electric charging points in 22 odd car parking spaces and or 3 disabled, then you'll have a problem that if somebody gets there before the other person. In terms of the disabled parking, looking at the drawing of the car parking, and visually they're all identical in size, which is 2.5 by 5 metres, but disabled parking is 1.25 more than that. So any disabled parking should be 3.75. So it's a problem for me in the sense that it's all laid out pretty, and they say all of these things. But if I was number 7 and I was disabled, how could I have a disabled parking standard when it's below the standard?
Clearly, disabled parking spaces always have certainly additional width.
So this is shown on the plans. They are the accessible spaces on the plan that's up on the screen at the moment. So that would be number 9, number 18 and number 22. So you can sort of see the extra width to the side of those to bring it up to the required width. In terms of electric vehicle charging points and what you were saying about, I think you were saying, we might want more in future than just those 5, and how can that be accommodated? I mean, that's partly going to be covered by the car parking management condition, and also whether anything else comes into building regulations in future.
We're not able to require all or more of the spaces to have electric charging points, because currently there is, correct me if I'm wrong, Julie, there is no national or local standard for vehicle charging points.
That's correct.
As a proportion of the overall unit. So I'm pleased that the applicant is providing 5, because it's more than some are providing, but it would be up to their own internal parking management plan to ensure the spaces were allocated, if necessary, to people who indeed had a requirement for electric vehicle charging. I take your point that we're trying to encourage this, but a ratio of 5 into 20 odd is quite a reasonable ratio compared with what we've seen on other developments. It's a move in the right direction. I agree with you, it should go further, but we can't compel them to do that.
Yeah, but it really is the point that we're supposed to be in a climate emergency being delivered by the council leader, and what we should be doing in terms of policy, we should be looking at ways by which we can drive this on, and we did at a previous meeting discuss the cost of putting in electric supply to a house when the house being built as against as a retrofit, and it was thousands of pounds more. The other point is a more sort of a simpler point, and that's the provision for the SANG, the financial provision for the SANG. It seems to me as if it's less than £1,000 a house, which I find a very minimal number.
My understanding is dependent on the number of bedrooms, isn't it? So these are obviously going to be generally much smaller units than we're used to seeing.
Yeah, I was only just doing a simplistic back of fag packer calculation. The 61 bedrooms, that makes the situation even worse. The 61 bedrooms, and I think the SANG payment is something like 40k-ish. And I think 40k, it just seems to me very little money to be as a payment for SANG. It just doesn't ring a bell.
Understanding that's completely a formula-based calculation. It's not one that we negotiate with the applicant. So we have a requirement for that amount of money. Simon, I assume you've double-checked that those figures are correct. Are you able to confirm that? The figures are correct in your opinion? I think Gary's point that,
yes,
the amount allocated for SANG seems low, but that is presumably because they're smaller units.
Correct, it is. I'd add that if it was 150 metres further away from the site, it wouldn't be required to provide any mitigation whatsoever. So it's within the 0 to 5.
How long is a piece of string?
Might I suggest they put in the infrastructure for the electric charging points on all the spaces, but they only put them in when the clients actually need them, because otherwise you're occupying a space with a charging point and a regular car can't park there. So that kind of kills the purpose of it. I know we'd all like everybody to do that, and I don't think they can require you to only have, if you have this particular flat, you have to have an electric car, so.
I think that is something that only the applicant can decide upon. Yeah, okay. Okay, well, we could add an additional informative encouraging the applicant to consider putting in the infrastructure for additional charging points. Although I would say is we do normally get, I'm just trying to find it here, we do normally ask for feedback on the from the utility companies as part of this, and it is my belief that utility companies would be alarmed if all the houses on a new development had electric charging points, because the provision of power will be insufficient, because they haven't caught up with the need to provide the sufficient power. It's the basic argument, Rochelle, that everybody in a street all has an electric car and they all plug it in the same time, the lights go out.
Yes, but if you have flat number 4 and it has a charging point and you don't have an electric car,
the parking management plan, I think we'll make some allocation for that. Okay, and I don't think there's anyone else indicating to speak. Does anybody wish to put an alternative proposal forward? In that case, members, I would invite you to indicate whether you support planning application 191573 with the report here and those items that are identified in the members' update, plus two informatives. The first informative, encouraging the applicant to have more than 10% PV on the roof, and the second informative is to encourage the applicant to consider putting in the necessary infrastructure to facilitate the underground infrastructure to facilitate the subsequent provision of electric charging points. So with that, those two informatives, could members please indicate whether they would support this application? And that is unanimously supported. Thank you, members. Right. Right, now the next application relates to two applications in Wargrave, and they are adjacent to each other. It may be possible when we're discussing this to not have to repeat some of our discussion on the second application, because many of the points we will have discussed in the first also apply. And we do have registered speakers on this application. So firstly, Simon, would you take us through the first of the two applications? We did consider whether it would be possible to take these applications jointly together, but they are different, and we would take them as two. But I would expect when we consider the second application, a lot of your previous questions will have already been answered.
Thank you, Chair. The application involves the construction of a 6-bedroom dwelling house on an existing larger than average site in Wargrave. It forms part of another application which will follow this application for a similar scheme for a 5-bedroom house. The site, as you can see on the screen there, is larger than the average in the area. It's a corner plot. There is an existing arts and craft building on the site. Demolition for that building has been approved via prior approval earlier this year. The northern, western and southern boundaries are framed by TPO protected trees. The basis of applying two applications for this site is solely for the owners to be able to apply self-build, or their intention would be to apply for self-build exemption for their property on plot 1, which is the western site, and allowing them to have the permission for the eastern site, which would then have the seal obligations. As an additional consequence to that, the affordable housing obligations for the infill dwelling would also apply to the plot 2, being the other application. So this application is for a replacement 6-bedroom dwelling, more or less in the or partly on the footprint of the existing dwelling. There have been 10 submissions, 5 for and 5 against. Wargrave Parish Council have also objected to the application, and it has been listed by the ward member. The primary concerns being for this application, the addition of a new access, the width of that being out of character in the streetscape, the loss of parking from that. On those two issues, there's no policy departure. It is acceptable in the street scene. Residents might just go back here, residents along here have no parking, on off-site parking, so their concerns are the loss of parking in this area here. So there's no policy departure, so it's acceptable. There's also concerns about the scale of the building, best depicted in the elevations, these being the front elevation to Victoria Road and the rear elevation, and this being the elevation to School Hill, which is the northern street. This dwelling is on the larger of the two plots at 1,600 square metres. As it is viewed from the street on Victoria Road, it is viewed at the eaves height here, so it is a less dominant building than would otherwise be apparent in the elevation. It is acceptable on character grounds. Third concern raised was impact on trees. The dwellings are separated from the trees by a sufficient amount. It is also subject to tree protection condition relating to that. There is not perceived to be any issue with root zones. Fourth issue being neighbour amenity. You'll notice from this application, from the site plan, that is well removed from the property boundaries. The single story element you view here is the single garage. So there's no amenity issues whatsoever with this application, or no adverse amenity issues. You'll hear from the neighbour at number 10. I think primarily the concerns relate to the second application that you'll hear tonight. The only other minor concern raised by residents was the nearby school, which is located up further to the south along School Hill. Again, conditions have been, delivery times have been limited to protect against school drop-off and pick-up times. As I've noted, affordable housing is in the other application. Ecology requirements, just as a additional note, the demolition of the house was under a prior approval. Council was not able to oppose ecology conditions. They form an informative in this application, so it is the obligation of the owner or the applicant to ensure that they meet the relevant legislation. The members' update, I should also note, just makes reference to the fact that the recommendation in this application should be swapped with the application for the other application. That is an officer error. The application in its current form is recommended for approval. Thank you.
Okay, thank you, Simon. We have people registered to speak. Firstly, could I ask Paul Kelly, resident, to speak? And then we'll move on to the applicant.
Thank you. Firstly, I'd like to just reiterate the unusual nature of the application and the confusion, inaccuracies and contradictions that this has caused. Two separate, as you point out, but highly related applications have been made for this site, resulting in errors in the applications that went forward to the public consultation, as well as the subsequent planning officer's reports. Regardless of the rationale for the split application, for which we raised concerns in our original objection letter, the applications remain separate with inaccuracies and contradictions within. Examples include the one that you've just pointed out there, which has been picked up just prior to the meeting, around the affordable housing recommendation being on the wrong application. Supporter and objector numbers are incorrectly stated for this particular application as 5 for and 5 against, when they're actually 6 for and 7 against, and 6 for and 9 against if you include the parish council and ward member. This includes representing the objection from number 5 Victoria Road, a key property opposite number 8, as a supporter rather than an objector. And thirdly, contradictions between point 59 of the application in front of you and point 61 of the other application relating to affordable housing and the order of demolition. Even the applicant's own architects seem thoroughly confused, submitting a response dated 15th September to the objections that contained over 10 factual errors. The point I wish to raise here is that this is a bit of a mess caused by the application being split in two. This confusion has caused problems with the reports, and so subsequently they haven't provided you as committee members with the full clarity needed to consider the applications. My main point of objection, however, on this particular application relates to the loss of parking on Victoria Road, as well as an impact on road safety due to a proposed additional vehicle access point onto Victoria Road. At present, this section of Victoria Road is used for on-street parking by homeowners not only on Victoria Road, but also on School Lane, which contains several terrace properties that don't possess any off-street parking and which is subject to double yellow lines. The stretch of road directly fronting the application site on Victoria Road is not only the most convenient, but also the only real opportunity for residents of those terrace properties to park close to their home. And so, unlike many roads, this on-street parking isn't the result of nearby houses needing to park second or third cars on the road. If an additional access point is introduced as proposed, this will reduce the number of spaces available by nearly 1/3 on that particular stretch, which in turn would exacerbate parking problems in the vicinity, as well as the associated safe use of the road by drivers, cyclists and pedestrians. This part of Victoria Road offers the main route to the junior school for much of the village, and hence is heavily used by pedestrians, cyclists and vehicles. The proposal is therefore contrary to policy CP6 F and G of the core strategy, which states that proposals will only be granted where they enhance road safety and do not cause highway problems, which this clearly does. This could be resolved if any scheme across the wider site simply used one access point, which is entirely feasible. As a result, whilst they don't object to the principle of new dwelling here, the introduction of an additional access point will cause highway problems due to the need for on-street parking to serve existing properties.
Can I now call Carl Ramsey, the applicant?
Okay, thank you, Chair. Good evening. I'm Carl Ramsey, live at 8 Victoria Road in Wargrave with my wife Victoria and our 3 children. Lived in Wargrave for 10 years and this property's since 2014. Property was built in 1899, so very dated, extremely inefficient when it comes to energy usage. So the plan was always to renovate. We lived in the property for a couple of years to get a feel for what we wanted to do. In 2016, we appointed our architect. 2017, we had plans drawn up to go into pre-application with Wokingham. And this was to refurbish the property originally. Next slide, yeah, thanks. We've had quite a few issues with the house. In September 2017, this happened where a ceiling fell in our child's room. Reality set in even with the proposed alterations. The house was still going to be old, and therefore we got the demolition approved and start from scratch. Next slide, please. We again engaged James, our architect, to change our plans to look at designing the new builds, and over the last 2 years, we've worked very closely with Wokingham Planning Department, going into 2 separate pre-applications, and taking the advice to ensure all our ideas were suitable and within planning law and policy. We've engaged with highways, had tree surveys, bat surveys also. Just to advise, we're number 8 Victoria Road. There are currently no numbers 2, 4 or 6, and we later understood the reason behind this when looking through the deeds of the property, that a plot originally was expected to have 4 properties on. Because of this, we do get developers contacting us all the time. However, we love the area, we want to stay there. It's never been a consideration. We're literally just trying to build our forever home. Next slide, please. We do have another application in, which I'll be discussing later, but we came to the decision that having the ability to have another property on site would allow us to look after our families in the future or have a home for our children when they grow up. Addressing one of the objections around Pegasus and on behalf of 10 Victoria Road about why we split the applications, we spoke with the SIL team at Wokingham Council who advised us to do this, as Simon said, to claim self-build on our main house rather than SIL being liable for both. We spent a considerable amount of time with all our neighbours prior to planning to let them know our ideas, take into account any concerns from them. All our neighbours, bar one, have been very positive and pleased for us. Please note that all the comments of support are from all our immediate neighbours, and the objections to the scheme actually come from people that don't live near the property, with the exception of 10 Victoria Road. Number 5 Victoria Road that you mentioned, he was the actual landlord, not the tenants. Next slide, please. There have been no objections to the design of the house or what we're trying to do, but those received from the public have been in relation to parking, trees or neighbour amenity. But as per the report, all these have been addressed, and we've had no objections to the scheme from the relevant departments, who are obviously the professionals. Next slide, please. Addressing the parking schemes, the scheme could reduce parking by 1 car. However, on Victoria Road, there is no official parking spaces with white lines, and street parking is available on the other surrounding streets as shown in purple. The red houses basically show the ones that don't have private parking that this could affect. Next slide, please. In summary, we've cooperated with the Council to ensure planning policy is met, and therefore this is why the recommendation is approved. So we're keen to get your approval today so we can move on and start our project, preferably before another ceiling falls down. Thanks.
Thank you. And the application was listed by the local ward member, John Horsell. He's not able to be here tonight. I think we have a statement that he's asked to be read out. Chris, could you do that?
Yes, I will. This applies to both the 8 Victoria Road application, so I'll just read it out the once now. I apologise to the committee as I am unable to be here tonight. I listed this application on the grounds that it is controversial. I'm neither supporting the application nor objecting to it, which is, I believe, contrary to what Mr. Kelly said earlier. Therefore, it is what should be referred to committee, so that all parties can see that the process is transparent and fair. I believe it could be improved so that it is not controversial if the applicant were willing. I refer the committee to the comments made by the Parish Council. The introduction of a new entrance to this location is incompatible with the street scene in relation to highway safety. If there is a single entrance to the whole site, the existing 8 Victoria Road site, the objection is withdrawn. If approved, the Parish Council requests the permitted development rights be withdrawn. Again, I apologise for not being here and thank you for listening. John Halsall.
Okay, thank you, Chris. So that concludes the speakers on this application. Members, Andrew, you're showing first.
Thank you, Chair. Mr Kelly's main objection relates to the loss of on-street parking and related road safety matters. I'd just like some clarification. From the plans submitted on page 143, it seems that the existing access lies alongside the boundary between properties number 8 and 10. On page 145, that access is no longer shown, but there's additional new access shown, with the cobbled sets. Am I right in saying that there will be 2 access points to this property? Mindful of what Councillor Horsall. Is that? Okay. I'm still not clear about the number of access points. Yeah.
I don't entirely understand the point. That my understanding is, sorry, can you draw my attention to the first plan reference you're referring to? Is that page 181?
Yeah, on page 143, the existing open. Yeah, it says existing opening.
Yep.
On 145, now I realise that this is on page 145. It's referring to the first application, so maybe that's the reason why the existing opening is no longer shown there. My question is basically, will there be 1 access point, or will there be 2? Bearing in mind Councillor Horsall's comments as well.
There'll be 1 access for plot 1 and 1 access for plot 2.
Absolute clarity, neither property has more than 1 access, the proposed properties, and none of the accesses are shared.
Thank you, Chairman. I was also going to ask about the parking issue, although I think clearly confusion arises because we're looking at 1 application at present for which there's 1 access point. We'll be looking shortly at the other application for which there's an access point also, unsurprisingly, in a way. And obviously the concern is that this is an area where there is a lot of on-street parking. There's a lot of competition for places. And this will marginally make the situation worse. There's no doubt about that, but I'm not sure that that is really something that we can use in our determination of this application. I'm not sure it's, in the end, if the highways officers think this is acceptable, then I'm not sure we can do anything about that. I was relieved to see the applicant's presentation showing, I don't know whether we can go back to the final slide with the design of the proposed building. I mean, that looks fine to me. I was slightly concerned when I saw the illustrations in the agenda, which didn't look as nice as that. Certainly they look much darker bricks and just darker altogether. This has a much better look to it. Obviously, this is a design that the applicant likes, and the applicant has worked on over a long time with architects' advice, and I'm a layperson simply passing comment, but it didn't, to me, look very much in keeping with immediately surrounding dwellings, but that looks much better, so I'm not going to pursue that any further.
Another question about parking, actually. I mean, from that picture there, it looks like it's got 2 garages, and it looks like you could park at least 5 or 6 cars on the drive, so I'm not quite sure what the problem is.
Pauline, it's not about whether the applicant's cars are parked on the street, it's the provision of the additional access for the proposed new dwelling would, in essence, the provision of the standard width access would mean you're losing at least one parking space. Okay. Sorry, Malcolm and then Rochelle.
Okay. I seem to remember visiting this last year on a site visit, that big corner site. I don't remember if there was a dropped curb on the existing site. I imagine there would be because it's a fairly large site. Do we know if there's a dropped curb at the moment? So that's got a dropped curb already, presumably. In which case, one of the houses will have a dropped curb, and there is already a dropped curb on the pavement. It may not be the same place, but it would be replacing one dropped curb with an alternative one. So that would be all right. And in which case the problem would be whether you want a second dropped curb for the sake of the second house. But the only difference that would make to parking on the street, and we know it is a busy parking, is just one car length, one car space. It's not as though, because it's a large house with lots of bedrooms, you have loads of cars parking down the road. There's plenty of space to park off-road if you have the one dropped curb, the space at the front. So I don't see losing parking space as a major concern here.
Come on to anyone else, I think it might just be useful. Judy, could you just clarify the position? Because the objector did particularly focus on the highways issues and the access point. Could you just clarify how this meets our requirements, the highways?
So in terms of the, yes, there is on-street parking at the moment. There's no doubt about that. But there's spaces as well. It's a public highway. There's no restrictions to stop anybody parking there. The new access would automatically, yes, sterilise that short bit of road to stop anyone parking there. Well, it is for one of the properties, but not for this particular application. Yeah. So it would sterilise a short stretch of the road, but there is capacity elsewhere on the road, so it wasn't deemed to be a highway safety concern.
Just for clarity, presumably if somebody wanted to park a vehicle that was taxed and insured, but they didn't use, such as a motorhome, in the road, perhaps the houses that don't have parking, they would be free to do so, wouldn't they? So blocking a space, in theory, for a long period. If somebody, I mean, providing a vehicle is road legal, it can be parked in the street if there are no restrictions, and that could just simply occupy a space for months on end. Yeah, okay, thank you.
Thank you, Chairman. My understanding is that all conditions should be reasonable and enforceable. And if I look at page 123, condition 17C, that the garage accommodation should be kept available for the parking of vehicles ancillary to the residential use of the site at all times, I cannot see that that is enforceable. Or, in fact, looking at the plan, necessary. Could I have a comment, please?
We're looking for clarity on 17C on page 123. Certainly, Angus, we see a lot of this where garages we do restrict garages from being available for parking of vehicles as opposed to suddenly being absorbed into the house as alternative uses.
Yeah, this is the fact that there must be a car available to be used for it, which I think is what this condition is trying to say, is unenforceable. But I'm happy to hear the officer's comment.
Yeah, okay. Could you elaborate, please, Simon?
The intent, it's a standard condition that's applied on a lot of applications. I guess the intent with this condition is to make sure there's sufficient on-site parking. They can convert their garage through permitted development rights. This restricts that, and it would, if they were otherwise able to do that through permitted development rights, it would mean that there'd be additional on-street parking demand. So this is intending to avoid that scenario.
Just also for clarity, the parish council was saying if the committee was minded to approve this, that they wanted permitted development rights withdrawn, and they are withdrawn in condition 17 on page 123, just for your information. Rochelle.
Just curiously, if this person didn't do anything and decided they wanted to put a driveway on the other side in one of these spaces where the new house would be, normally, would there be any problem for them having a drop curb there? So they could do that anyway, so what is the difference if they take the things with the house?
Fair comment. Well, it wouldn't be subject to the planning.
No,
it would be an application to
yeah.
the Highways Authority for the introduction of a drop curb. It wouldn't touch planning. Right, so do any other members wish to speak on this item? Does anyone wish to make an alternative proposal to the recommendation? Okay, so for purposes of clarity, we need to just recognise that the points here are, we can just get this absolutely clear, the recommendation for the application we have just considered, which is on page 118, is not the correct recommendation. The recommendation that we're being asked to consider relating to the application we've discussed is the recommendation on page 156. Okay, so you'd all just familiarise yourself with that? Yes, God. But it saved reprinting the entire agenda. So, members, could you please indicate, therefore, whether you wish to support this application, which is 191554? And that is unanimously supported. Thank you. And we now move on to the related application. On page 155, Simon, I'm sure you can probably be a little briefer on this one.
This application differs insofar it's a 5-bedroom house. It is 2.5 stories as well. It's on the smaller of the two plots at 685 square metres, concentrated on the eastern side of the site. It is smaller in footprint. It is utilising the existing driveway. Sorry, I'm missing the site plan, sorry. The neighbour objections are largely the same as the previous application. The difference here being number 10 has raised concerns in terms of amenity impacts upon their immediate upon them at number 10. Dominance from the building and overlooking and overshadowing. The windows in question here are, on the right-hand picture is a kitchen window. There's a view from the first floor bedroom window. The proposal was considered to be acceptable because of the setbacks of the development. If we go back here, there is a sufficient setback of 2.5 metres, which is 1.5 metres beyond what the guideline recommends. It is also set further back in the plot, which allows for the outlook that is achieved from the first floor bedroom in this photograph here to be largely retained. You'll see the existing dwelling here, so it sits in a general vicinity of that front building line. It was also felt that there was a degree of mutual overlooking or existing overlooking from the objector's property over the subject property. And in addition to that, the kitchen window, which is shown in the right-hand photo, does have a rear elevation facing south, which is larger openings, and they're considered the primary windows. So on those grounds, the amenity issues weren't of a concern. This application also includes the affordable housing provision as in accordance with the members' update. Thank you.
Again, just for clarity, the side-to-side relationship between the existing neighbour and the proposed new house is more than double the policy requirement. Because is that correct?
The setback to the boundary is 2.5 metres, where 1 is required.
Yep. There's
Separation of 4 metres, so the 2.5 metres is 1 metre more than what is on the neighbouring property.
Okay. Okay, was there felt any requirement for there to be any obscure glazed windows? Or was there some reference in there to this already that I may have missed?
There's no requirement for obscure glazing.
And that is largely because of the distance between the side-to-side relationship.
There are no windows at the first or the roof loft. The ground floor is separated by existing boundary treatments. Yep. family bathroom could be or should be conditioned. That may be an addition that you might want to add as a condition.
Could you, well, is it conditioned? Because I'd like it conditioned.
Sorry, I stand corrected. Condition 12 does require it to be obscured glazed.
Obscured glazed, fine, that's covered. Thank you.
My apologies.
That's right. Okay, members, who wishes to speak on this one? Oh, my apologies. My apologies. I'm getting ahead of myself. Could we ask Mr. Kelly to speak again? Thank you.
Thank you very much. I'd just like to highlight one inaccuracy on this report, which is in relation to supporters and objectors of this application, which was stated as 7 for and 5 against, when it's actually 5 for and 5 against. That aside, my prime objection to this particular application relates to neighbourhood amenity. As the officer highlights in his report, the amenity afforded to myself as the occupant and my family as the occupants of 10 Victoria Road is compromised by this application. The compromise relates to the proposed development being over 10 metres closer to my property than the existing building at number 8. If approved, the orientation and historical relationship between the properties will be significantly altered, with the proposed development of Plot 2 having a notable impact on general outlook, sunlight and daylight received, as well as being overbearing, creating a sense of enclosure and loss of privacy. There are two elements to the change in relationship with contravene policy and make the new relationship unacceptable, the most significant of which is the impact on the first floor bedroom of my property, which is currently occupied by my 11-year-old daughter and which has only one window, this facing towards the application site, which you've just seen. The submitted plans show bedroom 4 of the proposed dwelling with its only opening in the front elevation. The submitted plans, which you'll see on page 181, also have a 45-degree line marked from this first floor bedroom outlook. This helps illustrate that the proposed dwelling will interrupt the 45-degree line within approximately 5 metres of the window. At present, the 45-degree line isn't interrupted by the existing house until approximately 15 metres. The close proximity and siting of the proposed dwelling will result in direct views from the window of bedroom 4 of the new dwelling into my daughter's bedroom only 5 metres away, something that is not only contrary to policy R15 of the Borough Design Guide, which states that buildings must be designed and provide reasonable levels of visual privacy to habitable rooms, but is also something I would hope that the Borough Council would seek to avoid. Given this is a child's bedroom, I have also raised my concerns with the Council's Child Protection Department, and we have arranged or agreed to speak again after the meeting this evening. The second impact is in relation to the windows in our kitchen diner, and in particular to the outlook and light received, which is currently acceptable due to the distance between the existing buildings. There is a suggestion in the officer's report that the current relationship between my house and the current building at number 8 is inappropriate, and therefore this particular element of the objection can be disregarded. I absolutely dispute this. In 2012, you as a council approved plans I submitted which involved the inclusion of this bedroom window. So clearly a decision was made by yourselves at that time that the relationship which now exists today would be acceptable. In conclusion, whilst we don't object to the principle of 2 dwellings on the site of number 8, the impact of the current proposal will be substantial and significant in terms of the level of neighbourhood amenity provided, generating an entirely unacceptable relationship for both properties that's clearly in conflict with policy CP3A of the Wokingham Borough Core Strategy. I therefore urge you to refuse the application accordingly. Thank you.
Thank you, Mr. Kelly. And now Mr. Ramsey.
Not as many slides this time. Okay, thanks again for the opportunity to discuss. As I mentioned earlier, this is the second application for the additional building, which has still applied to it, has S106, which we're absolutely happy for. There's no worry about that. Next slide, please. After some family health issues, at a similar time to when we decided to demolish the existing house, we made the decision to move ours further into the garden and have the ability to put the additional property, as I said earlier, for family members to be closer to us. Again, we've worked with the council, went through the initial pre-application to get confirmation that there was no issue with the additional property, and then a further pre-application to take on board any feedback from the planning department with regard to the design, location of the building, and made sure it's planning policy, much in the same as plot 1. We made a number of changes over the last couple of years based on the advice of the planning department. And again, we consulted all of our neighbours with our intentions. We spent the most time with our neighbours, the Kellys, at number 10, and they raised concerns of the proximity to the boundary. So we took that into consideration and moved the plot 2 building further away than we had initially planned, even though it would have been okay to planning law. We did take up their concern on. Next slide, please. Again, the proposal had no objections from the relevant council departments, and only the public objection came from people who do not live near the property, with the exception of number 10. All the other immediate neighbours were very positive about the design and happy for us, and some of them obviously noted their approvals. The objections received around the neighbouring amenity levels have been assessed, and these are not to the extent that is unreasonable or would warrant refusal, as per the comments. You may note that the number 10 actually did an extension themselves in 2012, which actually reduced their own amenity space by bringing the property closer to the boundary than actually this application would be. And at that time, and after we purchased the property, there was an extremely large light blocking fir tree in the place of where plot 2 is actually proposed to be, which we actually removed after we brought in. That's actually on the next slide, just to give you some context, because actually that tree was huge and massive. So reference the window that was approved in 2012. I think the reason why that was actually approved, because it should never have been approved, because it actually causes us privacy problems now of them looking out onto us as we come out of our drive. I think the only reason it was approved was because of this huge, humongous tree, which was there, as I say, which we took out. So in summary, again, we've cooperated with the council and all departments to ensure pollen policy is met, work with our neighbours to try and have minimal impact on them where possible, and that's why we believe we've done everything correctly in order for the recommendation and approval to be confirmed. Thank you for your time.
Okay, thank you. And you will recall, members, that John Halsall's comments as ward member applied to both of these applications. I don't think it's necessary to repeat those. Before we go on to members, could we just get some real clarity on this issue of overlooking of a bedroom? Am I correct? We should be looking at the plans which are described as proposed site plan plot 2. If we look at the first floor plans, I'm a little confused because I don't see any side windows on the first. Sorry, we only see one side window, and that's a bathroom, which would presumably be obscure glazed. But the objector was raising the issue that was direct viewing into his daughter's bedroom. Could we get some clarification on that? Because as I say, assuming I'm looking at the right plan, the only window that overlooks to that side is a bathroom at the first floor level.
That is correct. There's no additional overlooking. The area in question is the top left photograph will remain largely as the driveway area. The building comes further forward. My understanding of the objection was more to do with the loss of outlook and loss of light to the room, but in terms of overlooking, I don't think there is any additional issue of overlooking from the application.
Right, because the building is set back differently, I was just wondering whether bedroom 4 of the proposed new dwelling has oblique views across to the flank wall of the neighbour's property. I didn't know whether that was the concern or not.
It could be.
That
could be a valid concern from the neighbour. It is a front-facing window, as most dwellings have front-facing windows. It complies with the front-to-front relationship. Okay. There are acutes overlooking matters, as there are in the existing house as well. So.
Okay, and the objector also raised the issue of the bream, the sunlight, the light condition. Have we taken that fully into consideration? And is it diminished, the concern, in your view, diminished because of the the reasonable separation between these properties compared with the sort of separation you'd have in many urban areas?
The building projecting further forward would reduce it somewhat, but the two windows in question are the side ground floor kitchen / living room window, and there are larger south-facing windows. It's a secondary window. There's a lesser expectation to light to a side window. The first floor bedroom window, likewise. The fact that there's a side-facing window arose from the modifications made to the dwelling, where the window, rear-facing window was internalised in a sense because of the addition to the rear. So that's an unfortunate but not unreasonable outcome.
Thank you, Chairman. Obviously, I can sympathise with Mr. Kelly at number 10 in the sense that there's going to be a quite big change in the relationship between the existing dwelling on the site and the new one in terms of its proximity to him. But it is important to note that this complies with our distance guidelines. I think there is a little bit of a concern about the potential, as you pointed out, Chairman, for oblique overlooking from bedroom 4's window. And I wonder whether there is any way we can condition. I notice there is a little area for landscaping at the side with proposed trees, I guess, to be put there, whether we could actually condition a tree in such a way that it would actually avoid overlooking.
I guess, well, firstly, it would probably take some reasonable time for a tree to reach sufficient maturity to provide any screening at the first floor level. And the other thing is of course, whether the introduction of a tree would provide reduced light to the applicant as opposed to the objector. So, either way is not ideal. I'd be open to other proposals, but my view is to introduce a tree would probably be not something that I could support because of it has counter reaction or counter problems. So,
just to follow up very briefly on that, of course, it is in the capacity of the resident at number 10 to put supplementary planting on his side. Indeed. And that may be a better way forward in terms of providing screening.
But on page 155, it says it's a 6-bedroom thing, but it says it's meant to be a 5, and on the diagram, one is a 6-bedroom plot, the other one's a 5-bedroom plot, isn't it? And I think they both say 6 on the opening page.
Can you direct me to the second paragraph?
On page, just turn it over now. Yeah. That's right. On page 155, it says it's a 6-bedroom dwelling. On the top. It says, well, item 55.
It's the
proposal, 6-bedroom. Okay. Yeah, but I'd say it's probably just a typo, but the point is it does say 6 on the top of both of them. It does, I agree. Depends how accurate you wanted the notes.
So, Simon, would you please, sorry, because this is make sure members have absolute clarity on this. The recommendation for the second application in Wargrave that we've just considered is the recommendation on page 180. 118. Sorry, 118. Right, members, with that having been confirmed, would you please indicate that you wish to support this second application? And that is unanimously approved. Thank you, members. We now move on to which is Red Hatch Drive, Early. This application has been listed by Councillor Smith, but I don't think she's here to speak. Oh, yes, you are. Sorry. Sorry. Yes. You're here to speak. And the planning officer in this case is Stefan Fludger. Stefan, over to you, please.
Thank you, Chair. Yep, so this is application 191879 at 31 Red Hatch Drive, Early. The proposed development consists of a side and rear extension, conversion of the existing garage to habitable accommodation, and changes to fenestration. As you've said, it's presented to the committee as it has been listed by Councillor Caroline Smith. Her concerns regard the size of the extension in terms of its impacts on neighbouring properties and lack of detail in terms of changes to the front garden. She does not consider the development to be in keeping with the character of the area. It's important to note at this point that the proposal has been revised to remove balustrading on a roof terrace which was originally proposed. This is to address officer concerns that it would have been harmful to the character of the area and would have resulted in harmful overlooking to neighbouring properties. Here is the site location plan, which shows that the house is on a corner plot and is a semi-detached dwelling. Here is the block plan, which shows the rear extension, side extension and converted garage. It also shows paving of the front garden and parking spaces to the front. This is the existing dwelling. And this is the proposal. The existing floor plan and the proposed floor plan. So this is the house as it is presently. The application is part retrospective as some development has commenced. You can see on the top left the house from the front and the bottom the house from the rear. So on the top in this image you can see the rear wall of the neighbour behind, which has no windows, and you can see the attached neighbour's extension at the bottom, which consists partly of a conservatory. This is just some general images of the street scene for you. At the top is the application property again, and at the bottom is a house slightly further down the street. And this is number 29 Red Hatch Drive, which is the house on the opposite side of Witchwood Crescent. So on the opposite side, on the opposite corner plot, which has similar side and rear extensions. And this was, just for clarification, this was the scheme before it was amended. So the proposal was for a single-storey site extension as well as other minor alteration. Concern has been raised with regards to the impact of the proposal on the character of the area, including paving of the front garden. As outlined in the report, it's not considered that the revised proposal would have a harmful impact on the character. It's modest in scale, subservient, and similar to other nearby extensions. The paving of the front garden is possible under permitted development and would not substantiate a reason to refuse the application. However, due to the presence of the upstairs opening doors and Juliet balcony, a condition is recommended to prevent the use of the flat roof as a terrace, which would prevent harm to the amenity of neighbouring occupiers. In terms of the members' update, the officer report indicates that a condition requiring the implementation of the proposed parking, which was 3 spaces, is required. This has inadvertently been omitted from the recommended conditions. However, It is clear that the space for three vehicles is already present, and therefore we don't consider this condition to be required. However, the condition requiring proposed paving to be permeable, which has been raised in neighbouring objections and by the parish, has been retained. A new neighbour consultation was carried out. One additional comment was received. This has been addressed in the update along with the second response from the parish council. Thank you.
Thank you, Stefan. Now we come on firstly to the two registered speakers. Firstly, Mr. Khan, the applicant. Hello. Are we using a PowerPoint on this? Okay. Yep. No, well, it's available. It's available. If you just wait a moment until we've located the PowerPoint. A bit of assistance. Yes, okay. Okay. If you want the slide changed, if you just say next slide.
Okay.
Change the slide.
Thank you.
Okay. Okay. Your time starts now.
Thank you. Thank you, Mr. Speaker. In general, I do not have any objection on the conditions put in for the approval of this proposal, and I am here to just assure that we would abide by the conditions put in. And one of some of the recommendation or objections that were raised by some neighbours who are not our immediate neighbours, but we have still considered their objections and modified the. I have asked my architect to modify the plan. If you go to the next slide, that is mainly around the front pavement, which objection was raised that probably it is disproportionate, or maybe we are not considering the front garden, keeping the front garden. So we have decided to actually not have the pavement fully in front garden and have only 60% of the area covered as a pavement and leave the remaining 40% as a garden space, which probably addresses the concern that one of our neighbors have raised. If you go to the next slide, probably it's the next one, and the next one. Yeah, so this is the proposal that, okay, the area marked in blue is what we are proposing to keep as a garden, and the rest of the area is as a pavement. But it will still be sufficient for 3 or 4 car parks. Okay. So that's
going to be an obvious. That would be an obvious question if you were reducing the paved area. Yes. Okay. Yep.
We have since we have done this pavement already, and we are driving, parking our 2 cars, and still there's space of 2 more cars in that space. So I think that's pretty much main change that we have done to our plan. The rest of it, as recommended by the planning officer, we would abide by those conditions. Thank you.
Okay, thank you very much. And now Caroline Smith as the ward member.
Good evening, Chair. Thank you. I think some of it has already been addressed, but I was going to say the reasons for asking it to be listed were mostly out of keeping, as already mentioned. But if the Planning Committee is mindful in approving, can we ask for some conditions? One of them has already been met, is could the flat roof not be used as a balcony without prior consent from Woking Council? Can the vehicle access be not allowed without prior approval? And could they put the fence back in Winchwood Crescent? And I think the applicant's already mentioned the change of the frontage and a submission of approval from WC for a hard and soft landscaping to the front of the property to ensure that there's a runoff not into the neighbourhood property and part of the design's sustainable drainage scheme. Thank you.
Okay, thank you very much. Just need to get a clarification on a couple of points before we throw this open to the committee. My understanding was that the use of the flat roof as a balcony is prohibited by condition. The balustrade that was, I guess, considered out of character with the area was also removed from this latest plan. Could you confirm that no new balustrading could be put in without planning permission?
No, so that's included in the wording of the condition.
Fine, thank you. Now, the work on the front garden that's taken place or is taking place, my understanding is all of that is permitted development. Is that correct?
It is possible to pave over the whole front garden under permitted development,
Right.
yeah.
But the applicant has told us that not all of the front garden will be paved over. And the only concern I have is that is not what is shown on the maps, the plans that are submitted here. So how are we going to address that?
So I haven't seen this revised plan until today. So we can't change the plan. No. So the permission that you would be granting, if you were to grant the permission, would be to pave the whole front garden. If the applicant was to not pave the whole front garden, I don't see that would. It wouldn't be in accordance with the permission, but we haven't required the whole front garden to be paved by condition anyway, so they would just be part implementing the condition, the permission.
Marcia, how do you suggest we tidy this up? Because this is not, we're now being asked to approve something that isn't as shown in the plans here. I happen to think what we're being asked to approve that isn't shown in the plans is better than what is in the plans here, and I doubt any member of the committee would disagree with that. But I prefer to avoid this having to come back to the committee with modified plans. So how might we address this?
It would probably be better if a plan could be submitted tomorrow and we can change the plan drawing number in the approved plans condition to approve the plan that you've shown us this evening.
Okay. Sorry, we need to have something that requires the paved area to remain available for the parking of vehicles at all times. So, for instance, it would not be acceptable to park a caravan on it or a big pile of building materials and therefore reduce the parking space from 3 to 2, for example. So, could you work with the officer to ensure that there's a new plan that addresses that and that you have a condition, Stefan, that makes sure that's tight? Okay. Right, over to members. Who wishes to speak on that? Andrew first. I beg your pardon. It's customary to go to the ward member first. And sorry, so we'll go to you first, Pauline.
Thank you, Simon. I would just wanted simply to say that with the amendments, I've got no objection to this at all.
I consider the revised plan dated the 8th of October to be a considerable improvement, in particular removing the previously proposed railings that presumably were there to enable the flat roof to be used as a balcony that would have overlooked neighbours. However, I believe that all 4 of the other reasons why early Town Council recommended refusal persist, and these are outlined on page 207, and I would ask members of the committee to consider those. I do note also, however, Stefan's comments in relation to points 1 and 2 in the update, the members' update that we've been given. The planning officer also noted that there are, in his oral presentation, that there are similar extensions at number 29, but my recollection is that the proposal, if approved, at number 31, would be more visible from the road end closer to the footpath than that at 29. I might be wrong, but my recollection is it's something to do with the slopes on that road. So I think that's just worth bearing in mind. However, okay, if we are minded to approve the application, I would also recommend 2 conditions. I'd recommend that in addition to the conditions on 4, 5 and 6 outlined on page 190, 2 additional conditions be attached. Now the first of these has already been largely addressed, and I'm really pleased at this. This is the requirement for submission and approval by WBC of a plan for hard and soft landscaping along the lines that the applicant has proposed. I think it is important that plan, as the Chair said, does also include conditions that would prevent any of the proposed parking spaces from being permanently occupied. The other condition that I would recommend is very different, and that's because of the slopes on this site. Submission and approval by WBC of a sustainable drainage scheme as part of the landscape scheme in accordance with policy CC10. This is, again, to do with, it may or may not be an issue, but to do with the slope of this land.
Stefan, where are we? I'm trying to see on here whether there are any comments with regard to drainage or from highways, Judy, relating to that. The issue about drainage and because of the slopes.
Are you referring to drainage of the front driveway?
Yes.
So we've recommended a condition instead of needing to approve an additional drainage scheme. We've recommended condition 6, which requires that the hard surfacing is either porous or provision is made to direct runoff into a permeable or porous area within the curtilage. So not into someone else, not into the neighbour's land either, but somewhere within the curtilage.
If the drawing we saw, the proposed area which the applicant was going to now retain as, or have as garden, that was the bit that was nearest to the other half of the semi-detached property. So that would presumably prevent water from the driveway running off towards that other property. Coupled obviously with the surface needing to be permeable. Stephen.
Just on that very point, Chairman, I'm a little bit confused, and I'd welcome somebody making me less so. We had a discussion earlier on about the applicant's offer to make the frontage of the building no longer just all hard standing for cars, but to bring in some landscape. And that's now going to be submitted as a plan, which we can then approve. But in fact, if I understand this position correctly, the applicant could actually decide under permitted development rights to revert to paving over the whole area without requiring any further planning permission. So we can't place any faith in that area of green acting as some kind of soakaway, because it may not exist in a matter of weeks or months. The applicant would be free to decide not to implement what we've just been talking about. So we can't actually place faith in that. We can, I think, require it to be a permeable surface, or a surface which will actually soak away in itself. I don't think we can rely on landscaping.
Surely, if a new plan is submitted and an appropriately worded condition is applied, we would at the same time withdraw any PD to prevent that being changed. Because otherwise, you're quite right, under PD, the applicant, well, I have no reason to believe that he would, could subsequently decide to make it all paved again. Yes, sorry, just one moment.
Sorry, I just want to clarify what you're going to do. The applicant is providing a new plan.
So you're going to delegate, presumably, to the planning officer in consultation with the chairman, or the usual wording. Yes. And then if it's not, if the applicant changes his mind, you're going to have to bring it back to committee because it's going to be a different. So it's almost as if you're putting it on, you're swapping the plans. This is the problem. This is the problem that Stefan pointed out, that you're not having given time to see this new plan. It's not actually before you, but you're delegating that part of the decision to the chairman. So if it's either that plan or nothing tonight, if it's not that plan, it's going to have to come back to you with the existing plan in here. I think is the point. It's almost as if it's being deferred. Does that make sense? Perhaps I'm confusing it even more.
I think I understand that bit. My confusion really is about whether having granted permission, if we grant or accept that there will be a delegated granting of permission on the new plan, which includes the landscaping area or retention of some garden in the front, as opposed to completely hard standing, what is to actually stop the applicant in a few weeks' time deciding that it's actually better to have the whole area as hard standing?
Tell you what I'm going to suggest we do, which I think achieves what we all want. We will consider this plan that is in front of us tonight with 100% paved. If we choose to approve this tonight, the applicant can then make a non-material planning amendment, a non-material planning application to change the paved area from 100% to whatever percentage he wants, and it will have to be approved. It will not need to come back to this committee because it's not a major or material consideration.
You're removing PD rights. You're removing PD rights.
Go ahead.
Just to come back on Stephen's point, if you don't require planning permission to pave over an entire garden, then he could do that tomorrow with his current garden anyway, so it's completely irrelevant, I would say. Yeah.
We're being sidetracked here. I would strongly suggest that you follow the recommendation I just made, which is to consider and, if appropriate, approve the plans that are in front of us. The applicant can then make a non-material amendment submission to change the arrangements in the front garden, which he would frankly be able to do in any circumstances anyway. So we will be approving what is here, because otherwise we're getting into the realm of approving something that isn't quite what we've got in front of us, and I'm not comfortable with doing that. So I think we should be approving what is in front of us, and the applicant should make, and I'd like to try and make some progress on that. Stephen, is that something you could live with, or does it raise other concerns that I haven't spotted?
Chairman, I just wonder whether there might be further comfort for the committee if condition 6 starts by the word "the hard surfacing hereby permitted," and that is substituted for the whole frontage of the property, so that whatever is put there and whichever area is covered at any time, that has to be permeable or drainable.
The point of actually being able to define that, and I don't think we can define that at the moment. What we can define that it...
Yes, we can, Chairman. It's the whole area between the house and the road, which I'm sure the planning officers can put into planning speak, but what I'm saying is whatever that is surfaced with has to conform with the rest of what is put in that condition.
I think we're making this unduly complicated. Stephen?
I'm very sorry to prolong this, and I know this is risking incurring your wrath, but I'm very aware that the applicant has made an offer to do something that people actually want, and I'm trying to find a way of ensuring we get that. If we approve the current scheme, we won't get it necessarily at all. Why would the applicant then have an interest in submitting this new proposal?
Okay, let's hear from the professionals.
If you didn't submit a non-material amendment, you would be in breach of the planning regulations because you wouldn't have complied with the approved plans.
Good point.
But that's not what he's built. He has retained a grassed area. So he has already constructed the paved area and retained a grassed area. That's how he wants to keep it. You are going to approve a plan that's slightly different. Hopefully, if you do approve it, it will be slightly different. And the way to regularise the planning permission will be through a non-material amendment.
I appreciate that, Mr. Khan, but unfortunately, believe it or not, the way things work, building control is completely separate from planning. So that's why we need to get this bit right. So I think, just bear with me a moment, please. In that case, I'm going to make a proposal to try and make some progress here. I'm going to propose what I spoke about 10 minutes ago, which was that we should, if members are minded to, consider the application that is in front of us, and if okay, to approve that application, and that the applicant will then be free to make a non-material submission. Sorry?
Free to submit if he wants, or required to submit.
I think required. Free, sorry, free. It's for free to submit. Yes, yes. Because it's PD. Okay, right. What? Fine, okay, so we have a proposal that's to second that. What we're voting for is my proposal. We're not supporting the application at this point. So I've proposed it, you've seconded it. Firstly, would everybody agree to that proposal? Fine, okay. So, right, so we now have a proposal that we will put to the vote as amended. Could members please indicate whether they're prepared to support it? And that is, after a bit of effort, unanimous. Thank you. Right. And so, Stefan, obviously, if you liaise with the applicant about his future requirements there. Okay. All right. Okay. Now we move on to the contentious bit. Okay. Swap planning officers, which one is leaving? Okay, members, the last item has been brought to us as an urgent item, and this relates to the preparation of the council's defence following the refusal of the Cutbush Lane planning application, and the fact that the council has sought legal advice in its preparation for the public inquiry. Now, members, you've all been provided with that legal advice on the pink papers. I should point out that if you wish to refer to any of that legal advice, we are required to do this in a part 2 part of this, which means we have to exclude the public while we consider that. Having considered it, we can then invite the public back in. So if we don't need to refer to that advice, and members accept the advice as given, we can continue with this part of the application, consider this application fully in public. Okay, does everybody understand that? Okay, so Chris, I think it's probably best if you just take us through this, but I will just remind members of the background that this proposal came to the Planning Committee with a recommendation from the officers for approval, but by a majority that approval was overturned and it was refused. And it's relating to the second reason for refusal, And you will have read the advice from a leading QC on this item, and we are being advised to drop that particular reason for refusal. Chris, could you take us through in a little more detail?
Thank you, Chairman. Yes, that's the background in terms of the application. It came to committee in June and was refused for 4 reasons. Reason 2 being affordable housing. And this was in terms of the affordable housing mix. The appellant proposed a 35% on-site affordable housing with a ratio of 50-50 social rent and shared ownership. The supporting text of policy CP5 suggests a 70-30 mix. This, however, must be noted that the text also states that the split should be a starting point for negotiations. This matter is also picked up in the inspector's report for the core strategy, whereby he encourages this position so that there is flexibility for sites coming forward, especially within the SDLs. In this instance, the split was, and an additional off-site payment of £250,000 was agreed by the council's housing team in lieu of fewer social rented dwellings. The purpose of this agenda item is to request that members withdraw reason for refusal 2 for the forthcoming public inquiry. The rationale for this, as Simon alluded to, is following the lodging of the appeal. Officers sought legal advice in respect to this matter by Neil Cameron QC, who strongly recommends that this reason is withdrawn. Just some further policy background, as the affordable housing policy isn't stagnant. Following the adoption of the core strategy, the Managing Development Delivery Plan was adopted. TB05 of the MDD states that any scheme that requires provision of affordable housing should provide an appropriate mix of accommodation on a site-by-site basis. This reflects the approach recommended by the Council's housing strategy and affordable housing SPD. This approach has been taken forward for planning consents across the SDLs to date. The applicant has agreed a 35% provision of affordable housing as required by policy CP5. Therefore, this element is policy compliant. In terms of the mix, the background to this is it was established through negotiations with the Council's housing team and the Affordable Housing Implementation Group. This is a cross-party working group in response to current local needs. Following discussions with the appellant in terms of the splitting and commuted sum, their advice to local planning authority was support the split put forward by, and officers made this recommendation in June. The mix can therefore be considered to be policy compliant. An appeal for the site was registered on the 17th of October. Following the appointment of Neil Cameron QC to represent the local planning authority, an appraisal of reason for refusal was undertaken by Mr Cameron QC. His appraisal of policy position and offer in regards to split are for the council to withdraw reason for refusal 2 as outlined in the report, as the scheme is policy compliant and we should focus on the other reasons for refusal. It should be noted that a decision on this will not, removal of this reason for refusal will not prejudice the council's case on reason for refusal 1, and we will still seek to secure the infrastructure required by reasons for refusal 3 and 4. The recommendation, therefore, is for the committee to agree to withdraw reason for refusal 2 from the appeal. Thank you, Chairman.
Thank you, Chris. I'll come to you first because you were involved in the original proposal. Stephen.
I was indeed, Chairman. In fact, I proposed it. It was seconded by Councillor Doran. And if I recall correctly, it was Councillor Doran who wanted this second reason for refusal included, and I accepted that. I obviously accept that having had very clear legal advice, we would be unwise to persist with reason for refusal 2. And as Chris has just said, removal of this would not compromise our ability to be able to argue robustly for reason for refusal 1, which was my main concern, that we had there a reason for refusal on which it was possible for members of the committee to disagree with the professional advice because it was essentially on a subjective issue. So I'm happy for us to, well, I wouldn't say happy, but I understand the reason why we need to drop reason for refusal 2, and I accept that and I think we should do it in order to strengthen our case at appeal.
Yeah, thank you, Simon. When I first was made aware of this from Chris, it raised some issues that I had some concerns, and they're not necessarily connected with the advice from the QC, but it's to do with the process. And starting off with, namely, our housing team has advised they cannot support the affordable reason at appeal. And so I thought, well, there's some issues there. So I raised some more questions. And further answers I was given was that the Affordable Housing Implementation Group is a cross-party working group. It is not a decision-making, but an advisory group, and is not open to members of the public. And the group is not mandated to make planning decisions, although the reference was they are deemed to be experts in terms of housing need in the borough. I would add that some members of this committee are members of that body. The decision for the split of tenure was made by housing officers and agreed with by the executive member for housing at that time, and is within the confines of planning policy to do so. The Affordable Housing Working Group had accepted the affordable housing proposals, including the commuted sum, and clarified that the affordable housing proposals reflected what was currently needed and in demand. Following our decision here, the housing team decided they couldn't defend the reason at an appeal, and that's we are where we are. The key to this whole problem for me is that the references is we are a quasi-judicial group as a planning committee. The Affordable Housing Working Group is a group that meets in secret. It consists of members and officers. They took the decision as to what the split should be in this case. They negotiated that with the developer and they agreed that. And that's why we had this problem as a committee. They had actually agreed this with the developer. So there's no way we could actually put that forward as a reason for refusal. And the issue I'm really trying to get at is, if we are the quasi-judicial group and they are an advisory group, then they should be coming to us with advice that on the day-to-day calculation, this is what the affordable housing split should be. They should not go and negotiate with the developer and then not tell us, and then eventually on the day of the meeting say, da-da-da. We had a very experienced councillor here, supported by another councillor here, who made a recommendation that was completely wrong, because the advice taken and the deal done with the developer without this committee knowing. And that's really my point. I will support the recommendation because I believe it's the right recommendation, but it does, the second time I brought this up, it does worry me that within this council there is business going on in private that is affecting the function of this committee, and it's this committee who should be making that decision, not them. And that's all I'm going to say.
I just add a couple of points. I mean, I would agree it's not common, but I can recall a number of previous occasions where sometimes, as a council, we've been obliged to drop reasons for refusal to avoid inevitable costs if we're trying to defend the indefensible. Also, there have been a number of cases where we have actually been, I think you'll be aware of this, Mary, as a council, we've been engaged actually during public inquiries when evidence is presented that clearly the inspector prefers, and we've been in positions sometimes at public inquiries where we've actually been obliged to agree to drop certain conditions to try and avoid applicants coming after us for significant costs. And as has previously been implied, this also enables us to concentrate on those that we can defend rather than to waste time, effort and potentially significant sums of money on trying to defend something that is probably indefensible. But I'm glad to hear that, Stephen, you as the proposer, original proposer of the first reason for refusal, are happy to support this, and I'm grateful for Gary for saying the same. Mary, did you want to add?
I just want to say actually, the housing group's recommendation to the committee is exactly that. It is advice to you all. You have the final decision. But the problem here is that what you decided, or it was obviously not in accordance with the housing policy people, the housing team, but the problem is that what you decided was against policy. So it's no coincidence that they agreed to this with the developer because it was in accordance with the policy. Does that make sense?
Yeah. Sorry, I thought Gary, you didn't want to have any further comments.
That's okay.
The point I was really making is that a deal was done with the developer on a set of conditions before this committee viewed those conditions. So it was a done deal. The other point that crops up is as well that there were members of that body who, I'm not sure whether they voted for or against or whatever when the decision was taken here, should they have declared an interest. They were part of a body that agreed with the developer, you can have these set of conditions. Then it's brought to here for discussion amongst all of us, and there were people in this room who are on this committee. Now, should they have declared an interest and said, the proposal that Stephen made, I can't support that or I can't debate that because I was part of the group who said something different, and the deal that was signed with the developer. Not that was done here, it was done elsewhere. And that's why I have the issue.
Never have been a done deal. They did not make an agreement with the developer. They simply said if there was any agreement, it would be that they would report to you all their recommendation on the affordable housing split. That's all.
If it was not a done deal, then what Stephen proposed was compliant within the overall principles of affordable housing. Slightly different as a 50-50, say a 70-30, say, but it was okay. But what's happened is, from the legal advice we've been given, it's very, very clear this is not the case. What was done was a done deal, whether you say nothing was signed perhaps, but it was an agreement made with the developer that this is how we're going to do it. And that's where the problem has occurred. And I'm trying to not say anything, but I do support the intention of the QC here.
I think the issue here really is that, in good faith, I think it was proposed by Carl and then adopted by me as a proposal that we should refuse because this wasn't compliant with policy as regards the housing mix. I now accept that we were wrong. In fact, it is compliant with policy, and that's really the point. That's the issue. And if it is compliant with policy, we have absolutely no grounds on which we can argue against it. And I think I think we failed to comprehend that the policy could be applied in a way that was going to lead to differential splits. And I think that's where the problem arose.
I don't think I was on AHIG at the point this decision was made, but I have chaired AHIG in the past, and I can assure you that it doesn't do deals with developers. What it does is discuss the developers' proposals and how they fit with policy, and it is a cross-party group, and it also includes members of the public, it includes tenants, representatives as well. It doesn't talk to developers, and it doesn't agree things with developers.
Right, sorry, Chris, yep.
I think I'd just like to add, we have to bring schemes to committee with an offer. We can't bring it unpicked because we'll get unpicked for not having an offer on the table. So we have to bring a scheme to committee with an offer to make a recommendation within a report. So we have to have those discussions.
Sorry, Chairman. So offer is one thing, recommendation is another thing.
way or another, the QC said, remove this, it will probably cause a problem.
We can put this to the vote now. So we're not needing to go into part 2 at all. So this will be just a recommendation as detailed on the supplementary sheets. And I'll just reaffirm the recommendation is that the recommendation is probably the briefest I've ever seen, and that is the recommendation relating to planning application 181499, that the recommendation or the refusal reason number 2 is withdrawn. Could members please indicate their support? And again, that is unanimous. Thank you for having to stay for the whole meeting till we got to your bit,
no problem.
Chris.